So with the consent
Yes.
of the petition document item number 29, my lord. Lordship asked me to in the records, my lord. But Lordship has ordered on 23rd, my lord. Thereafter, my lord, 4 days or state government holiday, my lord. I could not get hold of the record. Lordship will fix it on 1st of December, my lord. In the my lord, get hold of the record.
We fix it on some other day, taking into account 1st of December, I won't be there. Anyway, let it go before any other court. Huh?
That's a pattern matter, my lord. It's a pattern. Not pattern, my lord. Lordship made it pattern.
Then you have to bring it by 30th, because I won't be sitting on 1st. And then I'm not there for 15 days.
Let it be on 30. Yes. Then 30.
30? Is the matter on 30? At the top of the list? Taking into account that the records which were directed to be produced could not be produced.
Lord.
Yes.
Okay. Lordship, with the consent of the other side, I beg to mention item 14. We seek Lordship 2 weeks more time to file the affidavit.
Item number?
14.
The request for the learned counsel for APTCL, the matter stand adjourned to be listed after 6 weeks. In the meantime, the respondents shall, in the meantime, the parties shall exchange their affidavits. List the matter again on 12th of January.
The interim order,
Interim order passed earlier shall continue till then.
I beg to mention for this thing, one Contempt matter, most of my lord, notice has not been issued. Not for Contempt,
Why? This is a bench 5 matter.
my lord, for the deal. For regarding contract deal, non-payment of.
When did you file it?
It's quite long back, my lord, before 2 months back.
Then why hasn't it been listed?
Listed, but
Okay.
because nowadays, my lord, most of matter, all Contempt also coming forward.
Okay, list
And
first,
another,
1st of December.
another admission, my lord.
Why?
Because this is for compensation for COVID victim method. Husband of died during that, but his compensation.
When did you file? Long back.
Long back.
And has the service been complete?
Notice has been issued. Notice has been issued.
Is the service complete?
Yes,
Well, here, have it on 6th of December.
I'm.
I beg to mention for listing, Lordship. This 2017 method, this is pertains to ethics method. But the length in question is a partial length, bracket partial length. Now they again they serve in notice, Lordship, on 1811 of eviction notice. Again, during dependence of file method pending before court. So may I pay for listing of the tomorrow, Lord?
When?
Tomorrow, Lord.
Okay.
If you apply.
Please, your Lord. But I beg to mention with regard to item number 22, Lord. Kindly adjourn the matter. 22, Lord.
Okay.
Kindly adjourn the matter for the day, Lord. My senior is having some personal difficulty.
Okay, at the request of the learned counsel for the petitioner. Petitioner?
Yes.
Matter stand adjourned to be listed again on 5th of December 2023. No further adjournment shall be granted in view of the fact that the writ petition is of the year 2016.
Deeply observed.
Yeah, please, the Lordship. Lordship, I beg to mention petition for listing in a different column. Matter will be listed on first day of.
Why?
You know, in this which is petition, we seek to refund of rupees 9,70,000 on account of illegal realization of the established charge.
Illegal realization of?
On account of illegal realization of establishment charges.
Excise?
Yes.
Leave it on 6.
I am listing of the case, my lord. This is the before vacation, my lord.
this case was fixed for final hearing, but the affidavit was not filed, and that was filed before vacation. After vacation, it was supposed to be listed in the GMC market, my lord, your lord. So some they implemented, and they also some objection and a reply also came. So it may be
Mr. Borua is what do you call the word term is sine qua non of GMC market.
no, sir. My lord, I have 2 cases, but many parties are there. That is why I mean. So,
Okay, 11th of December.
but
Yes, madam.
I may be accommodated for the day only for today, item number 21, Lordship.
So and so appears on behalf of the petitioner and seeks for an accommodation plea. List the matter again on 7th of December 2023. It is made clear that no further adjournment shall be granted in the matter, taking into account that it's the 2016 matter.
Lordship, can it be after 7 because I'll be out of station?
Okay.
6, 7, and 8.
5th of December.
Yes. Deep blue pen.
Yes, why would you want to withdraw? Complied.
yes, Lord.
The learned counsel appearing on behalf of the petitioner submits that the judgment and order
06
dated
0604 2000.
6/4/2022 passed in WPC number 314/2021 have been complied with, and as such would not like to further press the instant contempt proceeding. Taking into account the above, the instant contempt proceeding stands dropped against the respondents. Contempt accordingly stands closed.
Deeply up.
May I please your lordship. In this matter, I received one SMS from the registry, lordship. So in this matter, I was appearing earlier for respondent 4 and 5, your lordship. Anyway, after receiving the SMS, I contacted the party who is undergoing treatment in Kolkata, lordship, and he is taking dialysis thrice in a week, lordship. So a short date may be given,
Wait,
lordship.
So that mention for taking of registration.
matter has started. No adjourn, no more thing. What is the matter about?
Matter is ancestral property, your lordship. So far I remember, the brief is not with me at the moment. Ancestral property, both respondent 4 and 5, they applied for mutation, and mutation are granted in their favor, your lordship. And after the mutation granted, the petitioner objected to that, and they came to Assam Revenue Board, your lordship. And Revenue Board also allowed that your mutation, lordship. That is the
Mutation in your favor. None appears on behalf of the petitioner on call. Your name?
Yes, Dasgupta, lordship.
Mr. S. Dasgupta appears on behalf of the private respondent
4 and
numbers 4 and 5. Who's taking into account that the petitioner is not represented, although the matter has been fixed. But is not represented. It's and on the last occasion, that is on 21/11/2023, it was specifically observed that no further adjournments would be granted. This court dismisses the instant writ petition for non-prosecution. Interim order, if any, stands vacated. Yes,
Lordship, I've been led by Mr. H.K. Das.
who is he?
My lord, Pradeep Kumar, he's in.
What is the matter about?
My lord, what had happened in this? My lord, there was an assessment order passed. After the assessment order being passed, I filed my return, and after I filed my return under Section 82, subclause 1, the revisional authority and its co-motor petition said that my refund application is incorrect, and he passed an order that is on 2010-2023, and he directed me for fresh assessment, where my assessment period was 15-16, and my already the assessment was completed. So my lord, that is a violation of Section 39 of the AVAT Act, which is a period of limitation for assessment is 5 years. My lord, I would like to show the paper.
Show me.
Yes, my lord. My lord, the first my assessment order, my lord, that is at 18/12/2020, my lord. That is at page,
This is for period 2015-16.
yes, my lord. So page 35.
Page 43.
No, page 35, my yes, page 43 is the revisional one. And page 35, my lord, will look into once.
18/12/2020 is page 43.
No, 18/12/2020, my lord. They were CSET and AFAT. Both was done, my lord. So because there was no sale in VAT, so the CST was taken into 18/12/2020, my lord.
So this is the assessment order.
Yes, my lord.
Okay, then
So my lord may see here the assessment has been 37, my lord. The assessment has been completed on the basis of the records and documents produced during the course of hearing and in case in any discrepancy of fraud. Page 37, my lord. The dealer is open for reassessment as per the provision relevant as a prologue. The assessment is worked out as shown below. So my lord may see my tax payable is 80,150. Total tax payable 80,150. Additional security paid is 2 crore 4,15,000. So I was refundable for 2 crore 27 lakh 8,044, my lord.
yes.
So accordingly, my lord, I filed my application for refund. That is at page 46.
Okay. Then
And thereafter, what happened, my lord? He asked me to produce. I was show cause notice was issued to me on 8th March 2022. That is Annexure 4, page 49, my lord.
this is done under what provision?
My lord, 82(1. So motor
What is
revisional
that
power, my lord.
81? So this is sumoto revisional exercise.
Yes, my lord.
Sumoto power is being
Yes, my
exercised.
lord.
Okay, then
And my lord, thereafter, my lord, at Annexure 10, page 115, my lord.
wait. Thereafter, what has happened? You have submitted a reply.
Yes, I participated in the hearing and everything.
Okay, then
And then, my lord, at page 115, my lord.
there is another show cause.
Yeah, there was a protection for books and everything with regard to the same assessment, my lord.
No, what is this? Page 56. Show cause against the discrepancy observed during the proceedings of sumoto assessment.
Yes, for the period
run.
2015-16, the same.
So
same
that was
assessment.
done on 2023. Then
Yes, my lord. My lord, then come to the assessment order, the impugn order, that is 115, my lord.
in 115.
15. My lord, at page number 117, my lord. And
Yeah,
then at
this is
18,
the
my lord, the
order of
final
sumoto
observation.
revision. Okay.
In
Then
view of the observation, discussion, and findings from the records available and produced by the dealer, I am of the opinion the refund application cannot be accepted and fresh assessment of the dealer is required for the period 2015-16 under the Central Sales Tax Act, taking into cognizance of the above finding. The refund petition is therefore rejected with a direction to frame fresh assessment of the dealer by assessing authority in Central VAT Audit Team. And my lord may see this was in 2023. So, my lord, already the period of limitation of my assessment has been already been crossed as per Section 39 of the VAT Act.
then
My lord, then he directed me for fresh assessment. And then, my lord, show cause was issued to me for participating in the fresh assessment, my lord.
Then
My lord,
assessment done.
no, my lord, no assessment has been done. I am challenging this order, my lord, impugn order, because this is as per the violation, my lord, by the Supreme Court judgment and even this Honorable High Court judgment.
What is it? A wet action. Hey, Kone,
My lord, I would like to read out the section 39.
yes.
So,
What is it?
so there is absolutely bar, my lord. So, my lord, may now this is a my lord, the Honorable High Court judgment here, and my lord, I'm also relying on the judgment of State of Jharkhand versus Voltas, my lord. There's a copy. My lord, here this is Northeastern Court. At that time, the tax matters were before the division bench.
How is this applicable?
My lord, it's applicable because there cannot be assessment after 5 years.
Why not?
My lord, because no assessment under the under section 39 can be completed under the 5 years of
What
assessment.
is the power of suo motu revision?
So, my lord, may see
The
it.
suo motu revision stays about 8 years.
No, my lord.
Yes.
My lord.
Kindly see section 82.
Yes, my lord. But my lord, it says that if passed by any authority subordinate to him, insofar as it is prejudicial to the interest of revenue, may after giving the
These are the conditions. Two.
Yes,
One is there has to be erroneous and insofar as prejudicial to the interest of the revenue. Then you kindly see.
yes, my lord, 8 years.
Provided
Yes.
that the
person not-
commissioner shall not pass any order under this section
after
the expiry of 8 years from the end on in which the order sought to was made.
yes, my lord, but
So the order was made when?
my lord, order was made in 2023.
That order which is sought to be revised.
That was in 2022.
So that has been sought to be revised, and within 1 year it has been done.
No, my lord, but that cannot be directed under the not under previous section 39, because any assessment.
Section 39 is on a different thing.
No, my lord, may I just place it here?
Are you saying that in view of 82, a person, he may suo motu revise, but he has no power then to assess?
No, my lord, my lord, then the entire period of section 39 would be put ahead.
No, section 39 is on a different aspect. Kindly see it. Section 99 says about the reassessment proceedings.
No, my
Kindly
lord.
see section 39.
Yes, my lord.
No assessment after 5 years. No assessment under the foregoing provisions
Provisions
of
shall
this
be
act
made
shall be made after the
yes.
expiry of year from the end of the year to which the assessment relates. Provided that in case of offense under this
auction,
act, for which proceedings for prosecutor have been initiated, the limitations shall not apply.
Right.
So under such circumstances, but if it is the power is given under 82 for 8 years, then the order is revised.
My lord, may I just substitute here, my lord? My lord, my assessment has already been done. My assessment has already been done. My lord,
Your assessment was done and therefore it was revised.
no, my lord, assessment has been done, my lord. My lord, may I just-
Your assessment I've seen 18 to 2020.
Yes, my lord.
Then after that it could be revised within 8 years.
No, my lord, may I just place it here, my lord. My lord, a direction for revisional, my lord, a power under 82(1) cannot contain me the power of section 39, my lord. Because my lord, because my lord may see there has been a
You mean to say, are you submitting one thing that 82, by virtue of 82, although 8 years have been given for making a suo motu revision,
yes, my lord.
and a suo motu revision is made to that order, then the assessment cannot be made pursuant to that.
My lord, section 82(1) talks about two opinions. On the based on two opinions, the 8 years period will be liable. My lord may see the 82(1) and my order. My lord may see the assessment order and the assessment order of the assessing officer. He has not taken up into any kind of he has not taken any new evidence or anything on record to show that there is a procedural of interest or there is something against the revenue. My lord, there is a finding by the assessing officer that my F form and C form has been absolutely correct.
That is a different thing.
Yes, my
You
lord.
show me,
My lord.
if you are saying that yes, the suo motu revisional order is bad
Yes,
because of the fact that the condition precedent
Yes, my lord.
for invoking the suo motu revisional powers
My lord.
is not there. It is a different aspect, but that is not your submission.
My lord, that is also one of my submission of my pleading.
That should be your submission. Don't make that submission of limitation unnecessarily.
So my lord, my submission is also 82.
Unnecessarily this 39 and all.
82(1)
You don't expect this type of submissions.
82(1) is also my submission, my lord.
82(1) is your should have been your submission only to the effect that 82(1) says that it has to be erroneous and should be also prejudicial to the interest of revenue.
Yes, my lord.
Now you may say very well that yes, the order which has been done, exercised or power has been exercised by the authority without the order being erroneous or prejudicial to the interest of revenue. That should be your submission.
That is what my lord. That is what
That
my
is not your submission.
So that my
You have made unnecessary submission as
No.
regards assessment.
no, my lord.
Yes, you are led by Mr. H.K. Das. Ask him. Make him there.
I'll just try.
Don't make this type of submission.
Lord, I'll just try to learn. Just it file. Just try to Lord, add what my friend. I'm not on the limitation part, my lord.
Don't be.
No, I'm not at all. Although I have, my lord, stated about that. My lord, my contention is that if we go by section 82(1), two ingredients, preconditions, my lord, both are to be fulfilled, not one of them. Erroneous order and the assessment is prejudicial to the interest of the state. So for assessment is prejudicial to the interest of the state, my lord,
Of the revenue.
of the revenue, my lord. That question doesn't come here because not a single sale took place within the state of Assam. My lord, all were taken from Meghalaya by my lord, issuing my lord, valid C form, F form, and all were my lord, stock transferred to West Bengal and Bihar. If your lordships kindly considers the assessment.
Where is the other side? Finance and taxation? Nobody. Their names have been shown.
Yes, man. Names definitely.
Finance is there.
Yes, my lord. Finance is a party, my lord. I'm not very sure whether in the cause it has been shown. I'll just check up and my lord. My lord, name is showing as the fine. And second issue is that
Now, what is the stage, Mr. Das?
My lord, the stage is that, my lord, they are going for a fresh assessment. My lord. And in my humble submission, my lord, without fulfilling these two ingredients, that the order is erroneous and prejudicial to the.
Let them go ahead with the assessment. And you participate in the said assessment proceedings, but whatever the demand shall not be imposed upon you till the next date.
Uh,
Let them do the assessment.
May I make a submission, my lord?
Yeah.
My lord, so far as the erroneous thing is concerned, my lord,
Whatever may be,
my lord,
we will look into it that as to whether it is erroneous and prejudicial to the interest of the revenue. You are protected. You see, things should not be stalled. Let the assessment go on. Doing an assessment would not have anything to the effect.
true, my lord,
But
absolutely correct.
if any assessment, any demand is raised, the same shall not be given effect till the next date. That is, you are
One
protected.
thing is troubling me, my lord. Just to place before your lordship. My lord, I am a businessman, my lord. I am doing business. At a security deposit, my lord, I deposited something crore rupees in your account, my lord. Now, an assessment has been made by the assessing officer, my lord. He found that yes, absolutely things are absolutely correct. My lord, he has checked the vehicle numbers and all.
Mr. Das, as to whether the condition precedent
Yes.
for suo revision was there or not, can only be decided after hearing the other side. So let us give them an opportunity for that. Although that order of the suo revision does not reflect so.
Yes.
Does not reflect as to why the suo yes, it says that these are the various discrepancies which were found and all these things. But whether that would amount to being erroneous and prejudicial to the interest of revenue can be only decided after hearing them.
Yes, my lord,
So
absolutely correct.
what
That's
is
why-
what is the worst which will happen to you if the assessment proceedings are carried out? Nothing. The only problem which you may face is the demand. The demand should not be made effective or enforced upon you till the next date. Yourself.
My lord, lordship is correct, my lord.
Mm.
When I'm just trying to make out a prima facie case with regard to lordship is correct that they are to be heard. In the meantime, my lord, I'm praying for the stay of the assessment because of the reason that
Why should you
already-
stay the assessment? No, the question of
already
stay.
have undertaken a
You can only be worried about the demand being made. If an assessment is being carried out
Yes.
and in the assessment it is made, something is found that you are liable to pay.
Yes.
That's it. So let the assessment be carried out. That will be subject. First, the assessment will be subject to the outcome, and no demand which is being imposed upon you shall be imposed till the next date.
I'm pressing it because I'm alleging perversity in the decision-making process.
Absolutely. If we
Because-
look into later on, I'm making it shall be subject to outcome. You are protected. Your only problem is what? Your problem is to the effect that if an assessment is carried out, not only whatever is due to you would not be given, but also there might be a demand as per what has been observed.
Correct.
So you are only worried for the time being as regards the demand. So that is the demand which I am protecting you.
Lordship, fine,
I think that is a win-win for both of you.
fine, man.
The issue notice, making it returnable by January 8th, 2024. The learned counsel appearing on behalf of the petitioner, Mr. H.K. Das, submits that all the respondents herein are normally represented by the Finance and Taxation Department of the Government of Assam, and their names have been duly reflected in the cause list. Be that as it may, it is seen that none of the councils appearing, standing councils of the Finance and Taxation Department of the Government of Assam is present when a matter has been called. This court grants the liberty to the petitioner to take steps upon the Standing Council of the Finance and Taxation Department and serve extra copies of the writ petition by 30/11/2023. The case of the petitioner herein, this court have also heard on the question of the interim prayer. The case of the petitioner herein is that the respondent number, who is that? The additional commissioner,
Yes.
Huh?
Yes, my lord.
who has
Additional commissioner.
exercised that power?
Respondent number 3, my lord.
Submit that the case of the petitioner herein is that the respondent number 3 have exercised the power under section 80, purportedly under section 82 of the Assam Value Added Tax Act 2005. 3 or 5? 3, no?
2003, my lord.
2003.
Yes.
He submits that for exercising the suo motu revisional powers under subsection 1 of section 82 of the Act of 2003, the order of assessment has to be erroneous and should be prejudicial to the interest of the revenue. He submits that a perusal of the impugned order would show impugned order dated
It is dated 2010-2023, my lord.
2010-2023 would show that there is nothing reflected in the order that the order which has been sought to be revised is erroneous and prejudicial to the interest of the revenue. The learned counsel, referring to the various judgments of this court, had submitted that these twin conditions has to be satisfied before initiating any proceedings, before exercising the powers under section 82 of the Act of 2003. The learned counsel submits that upon passing the impugned order dated so and so, the respondent authorities are now proceeding to assess the petitioner for the period of 2015 and 16. And as such, the said assessment proceedings so initiated ought to be stayed pending disposal of the instant writ petition. This court, having heard the learned counsel, is of the opinion that the question as to whether the exercise of the powers under section, question as to whether the twin conditions for the exercise of the powers of suo motu revision was there or not can only be decided upon hearing the respondent authorities. Be that as it may, it is the opinion of this court that it would not be in the interest of in the interest of justice to stay the assessment proceedings which have been initiated on the basis of the impugned order. Be that as it may, this court, however, observes that if in the assessment of proceedings any demand is raised upon the petitioner, the same shall not be given effect to till the next date. This court further makes it clear that the impugned order dated so and so shall be subject to the outcome of the writ petition.
Deeply.
I
Much
appeal
obliged.
for 1, 2.
I don't know. You have not appealed.
My-
I can't help you when a matter is called.
Deeply.
At number 2 to 4 orders they vacating.
Yes, what is it?
My lord. There is an IM, my lord, 4299 of 2018, my lord,
For what?
which is for cancellation and modification or alteration of order dated 18/5/2015. my lord.
In view of the above, the aggrieved petitioner is given the liberty to file appeal. Huh? Which order? Which order you are asking for vacating?
18/5/2015. my lord.
2/3/2015?
No,
Which
my lord.
order?
18/5/2015. my lord.
Where is it?
In IF 4299.
IA 4299 page.
My lord, in paragraph 6, my lord, it's page 5, my lord. Last paragraph.
Page
Page 6, 5, my lord. Paragraph 6, I have mentioned, my lord.
which order are you asking for vacating?
My lord, order dated 18/5.
Where is that? Where is that order?
Selector 5, my lord.
Page challenge is made to the order. It is not. Yes. So there was a direction that the in charge secretary respond number 8 shall continue until the next date fixed. Then what happened? This has been passed in WPC number
2466.
huh? 2466. Two, 466. Then why are you filing this application? It was only till the next date. It has not been extended.
My lord, I am on instruction that the matter has become instructed.
Which one?
That
I
Not-
has become infructuous. Because there is no stay. Yes, what is your case?
I am for the reputation of Lordship. We have challenged regarding the appointment of the secretary of a cooperative society, Lordship. Impugned order is page number 50.
No, the period is for 5 years.
5 years.
There was a direction for under section 9 for under 41(6) for an in charge. Has the election happened?
Yes, Lordship. Here in
Then what remains in these matters?
new board has been constituted already.
Then what remains? Nothing remains in these matters.
Exactly.
All the requisitions.
Yes.
Same.
Yes.
D4, my lord, regarding dissolving the society, my lord, under section 39. That is also infructuous because of the fresh election, my lord. Fresh election hold, the board taken about charge, my lord. Now,
The learned counsel appearing at the bar submits that pursuant to the dissolution of the cooperative society in question, that is, what is the name?
Latu Ashram Cooperative Society.
So and so. In Namtu Silo. Where is it?
Yes.
Where will I get the name?
Yes.
Latu Dasgram Cooperative Society.
Yes.
By the register of Cooperative Society and exercising the powers under 41(6), a new what is that? A new board have already been constituted pursuant to an election. And as such, all the petitions have become infructuous. Taking into account the above submissions made at the bar, the incident, all the writ petitions stands closed as it had become infructuous. The interim orders also passed also ceases to have effect as all the writ petitions have become infructuous.
My lord, with regards to my lord appointment of secretary is concerned, there is an issue. That how do you decide under
What
section 40?
secretary? That secretary has nothing to do here.
Yes.
That is a new board will decide, that is their look.
Yes.
Okay. I
Lordship, in this case, Lordship, my son.
Oh,
was-
this one. Postmortem.
Yes. Forensic examination.
Yes, what do you mean by this? In our opinion, the cause of death is due to syncope resulting from coronary artery insufficiency,
That reason is
probably
taken
due to
postmortem.
underlying cardiomyopathy
It's an
of
opinion
the
of the medical officer who has done the postmortem. That is,
Then,
and so far as this FSL is concerned, my lord, city doesn't contain that Visera has stand for.
huh?
No, FSL report is there because it was not signed, my lord, as per their instruction.
Whom should we direct for making an inquiry?
My lord. My lord, respondent number.
In this petition, my lord, no
No,
police
not here.
officials are.
Huh?
In this petition, my lord, no police officials are made respondents.
No, it's okay. But whom should we direct for making this inquiry? We should appoint a commissioner, isn't it? As per the Guwahati High Court rules, this court can appoint a commissioner on these materials.
Right.
Whom should we make?
Your lordship, is it?
What? Whom make it? I am asking you, whom should we make? Some retired district judge, because he will be unable to understand this aspect. Huh?
My lord, here, my lord, we have prayed for, my lord, to conduct a judicial inquiry as well as for
grant of etiquette.
That's understood. First, the inquiry has to be there as to whether there has been or not. Whom should we appoint? Find out. Let me know next time.
Any retired dis-
I think that will be better, na? Because they will be knowing
Yes.
as regards they can very well look into this aspect. And the state has to pay the commission charges.
My lord, the one judgment, my lord, I have found
Ah.
here, my lord, put the the latter part, my lord, by giving some adequate compensation. My lord, direction was, my lord, given to make an inquiry. Passed by a division bench. of law.
How can this court first hold that it is required that there was a negligence? If we look into the postmortem death, it shows that it was on account of an underlying cardio problem for which you expired. That is what is the postmortem. However, the postmortem says that to rule out that there is any poisonous thing to that effect, so there is a requirement to send it to the FSL. That is what it was done. Now, whether there was a FSL done or not, that is not known. But this
They
court,
have said, my lord, it was not sent for forensic. My lord. But I have
no, they say
understand.
that we have not been able to find out. But
Last
no
paragraph,
record
my lord,
found in
second
the
line.
CD sending of vice versa to the director FS.
That much we can find.
So they may not have sent it.
Maybe.
But is it your case that he died out of poison?
My lord, worse then is that, my lord, I have in paragraph 21, I have categorically mentioned, my lord, the petitioner begs to state that it is very difficult for the petitioner to prove the allegations made by providing adequate evidence, as everything has occurred inside the jail. However, the petitioner is very much hopeful that actual proof will be unearthed if an impartial inquiry by an impartial body, preferably judicial inquiry, is conducted into the entire episode. Petitioner humbly pray before.
So once there is an inquiry being conducted,
Yeah.
then only we can impose the cost or find out, yes, there was something wrong or not.
Yes.
So think about it. Whom should we give? Because the government has to, some commission has to be appointed.
Yes.
For the point, because as they have not been able to find out, and this court is not in a position to do so. There are a few judgments where I think sitting district judges have been also asked to do it, but just find out whether it is there or not. Because I have not passed any direction in this manner earlier. Only in one case I have directed, exercising the powers under Guwahati High Court Rule. Yes. Kindly see chapter 5A10. All questions arising for determination under these rules shall be decided ordinarily by affidavits. But the court may direct such questions as it may consider necessary be decided on such other evidence as it may deem fit. Where the court orders that certain matters in controversy between the parties shall be decided on such evidence, the procedure prescribed in the Code of Civil Procedure 1908 for trial of suit shall, so far as applicable, be followed. So it will be done in terms with Order 26, Rule 10 and 10A. Okay. So in that regard, I have directed for something, because here we need a medical opinion, not only of that, for which we should appoint a commission for the purpose of finding out. So that I can do. Huh?
Chief is referring that
Chapter 5A, Rule 10. So whom should we give it? Let's find out. Because one has also to take note of that
my lord, one judgment I have found, my lord,
Hmm.
that says, my lord, its survey of the case referred above goes to show that it is now well settled that the defense of sovereign immunity is not available when the state or its officers acting in the course of employment infringes a person's fundamental right of life and personal liberty as granted by Article 21 of the Constitution. And the state can be directed in a writ jurisdiction under Article 32 and 226 to repair the damage done to the victim by paying appropriate compensation. In the case
Mr. Counsel, what you are saying, there is no quarrel. You start from reading from those judgments from that, what do you call, that Upohar cinema, that case. If you look into it, what the Supreme Court said, that in a writ court can very well direct, DK Basu, these are all cases by which, but to find out as to whether there has been a negligence. Because if he has died out of his own accord, the question cannot be, there cannot be a case of negligence. But here is a case that has to be ascertained by a fact-finding body. So therefore, I am asking you, just think about it. Whom should we give it? We'll take it up at 2. Huh? I'll dictate it.
or my lord, you can have it on the next week. My lord.
Okay, we can find it out. Miss M. Bormon, appearing the junior government advocate, have pursuant to the order dated 10/10/2023, have placed an instruction issued by the Superintendent of Police Golaghat, whereby it has been mentioned that that during conducting the PM or examination, concerned doctor Vice Viscera doctor preserved viscera for chemical analysis, but no records were found in the CD sending of the viscera to the director FSL Kahilipara, Assam, Guwahati. It was also mentioned that the opinion in the postmortem report stated that the cause of death is due to syncope, resulting from coronary artery insufficiency, properly due to underlying cardiomyopathy by the deceased. The said instructions are kept on record and marked with the letter X. This court, further, upon hearing the learned counsel, finds it is of the opinion that to ascertain the actual, to ascertain the facts which led to the death of the brother,
My son,
the son of the petitioner, an inquiry would be required to be conducted by appointment of a commission in terms with Rule 10 of Chapter 5A of the Guwahati High Court Rules 2022. Accordingly, this court therefore sought for suggestions from the learned counsels appearing on behalf of the petitioner and the respondents as to who should be appointed as the commissioner for making an inquiry as regards the death of the son of the petitioner. The counsels appearing on behalf of the parties sought for a short adjournment to list the matter again.
First of December,
I am not there. This-
30th. One judgment, my lord, of this High Court, my lord, that fine, my lord, it was directed to be conducted by present sitting judge. It was a case of Shivsagar, my lord, and district judge Shivsagar was directed.
That is what I am saying. A district judge Shivsagar, that is why a district judge could be. So that is what I was saying. That they have be
My
done.
lord, present.
Show me that.
Para 1 is the fact, my lord. Para 2. Is para 2, my lord.
We'll do and list the matter again on 18th of December 2023. We'll look into that because this, I am personally not of an opinion of giving it to the district judge. Let it be something more, because you see, they are otherwise also very busy.
Yes.
So to impose upon them, but instead of that, if we appoint a person concerned, then it would be more better. And we can give a particular time within 2 months so that he completes the inquiry and thereby directing these officials to also submit. Maybe a person out there, this is happened where?
Golaghat, my lord. District jail Golaghat.
To Golaghat. So we can appoint somebody out there in Golaghat from here because he has to go to Golaghat. So we can think about Golaghat district judge or anybody who is there. Just find out anybody.
Obliged.
Because if we appoint an independent person,
Yes.
then there has to be commission charges. And these commission charges has to be paid by the state. But you have any case?
Made the option. My lord, insofar as the issue concerned, the petition,
That is, the issue is,
the issue is, I was blacklisted earlier for a period of 3 years.
but can they impose the condition of 10 years?
They have taken a stand that since the value involved around 50 lakhs odd, so they have taken a stand. And to support their contention, they've also said the Honorable Guwahati High, the Honorable Meghalaya High, as also the banks and all, have issued similar, have retained similar clauses in tender notices of the respective institutions. That's what their basic stand is. So, my lord, I have done the research. It is in 2 parts. Firstly, all the cases of blacklisting, starting from day 1, develops along the line as to what is blacklisting, then what are the preconditions of blacklisting, and the safeguards person would have. There is no single case to touch upon this part as to whether such a clause could be there. Now coming to the other part of
What do you say about AFCONs?
AFCONs and all deal with the irrationality.
No. not only AFCONS, Silpi Construction,
All.
and also New Galaxy, wherein it say that the author of the document is the best person to know
Precisely.
what is the requirement as to whether whom they want. And as such, it should not be, and if this court finds it also that, yes, this points, whatever interpretation they have given or what they think may not be right, then also it is not for this court to sit over it under 226.
Precisely. So these chain of thoughts, which have culminated into judgments and judicial pronouncements, proceeded on the premise and the touchstone of Article 14. Article 14 would go to the extent of proportionality, irrationality, whence to the unreasonableness. Now all these things come in the sweep. I am for the moment not on Article 14. I am on the touchstone and the conflict of 19.1G, 19.6 to 290. I'm a different, I'm facing it different. The power to enter into contracts of the government flows from 290. And my right for the freedom which I enjoy, albeit with reasonable restrictions, flows from Part 3, Article 90. We are concerned with 19.1G. The 19.1G guarantees a freedom subject to a reasonable restriction of 19.6, existing law or other law. Now, so far as the state to enter into a contract, it's 298. And the other interpretation of 298 has given rise to the power of blacklisting, although it's not a codified. It's a constitutional right which flows from negative. Now, if we take it this way and we are on one page, then 298 gives them the power to blacklist, which in other words is a law so far as the reasonable restriction of 19.6 is concerned. My most respectful submission is a tender clause is not a law within the ambit of 19.6 and Section 13.3 and Article 13.3, so as to enable them to put a reasonable restriction on their fundamental right to trade. May I place each other? Develop it. There is no judgment in the line I'm developing it. There is no judgment, not at all. So therefore, this would give this honorable court that room to adjudicate with as to whether the reasonableness of the clause, I am not on Article 14, meets the constitutional requirement. The conflict is not between constitutional provisions. It is a conflict of the fundamental right vis-a-vis a constitutional right. Herein, I cannot bring in the test of repugnancy. In this case, I cannot bring in the fit and substance, severability. None of the doctrines would apply. The only doctrine would apply is that the supremacy of the provisions of the Constitution vis-a-vis a fundamental right protected, and in this case, to a citizen of anything. There are judgments to show an incorporation may not be a person, but since the body has the persons, they would also enjoy the fundamental rights. May I just invite my attention to the Constitution, if I may read. So I thought of it in this way.
What did you say? That if there is a clause to the effect that a person having previous conviction, he would be barred.
That does not flow from the Constitution. That is a wishful thinking. What I am on is that the right to contract or right to restrict a person from entering, that's debarment,
The same
flows from 298.
No, same here. A person who is convicted,
Why not?
person if he is convicted, he is barred from participating.
If it be so, it must be under a law. Under Article 13, it must be an ordinance that is promulgated by the President on the Governor under Article 123 or 213. It must be a regulation that flows from the authorities of the state. It must be a notification notified by the state under an act. It must be a bylaw, a custom, or a usage, and nothing else. So if there is a power to be traced under the 7th schedule from the respective list, which has given them the jurisdiction to bring out something which the Constitution recognizes as a law, certainly I have no case. The power to debar me is under Article 298 and nowhere else. If I invoke Article 298, I suffered my fate. I crossed my period of blacklisting.
Show me.
May I
What does it say about 290?
may I invite the
Yes.
19.1 or 298? (298) Power to carry on trade, etc. The executive power of the union and of each state shall extend to the carrying on of any trade or business and to the acquisition, holding, and disposal of property and the making of contracts for any purpose. Provided that A, the said executive power of the union shall, insofar as such trade or business or such purpose is not one with respect to which the parliament may make laws, be subject in each state to legislation by the state, and B, the said executive power of each state shall, insofar as such trade or business or such purpose is not one of the respect to which the state legislature may make laws, be subject to legislation by the parliament. It follows to 299. Contract. All contracts made in the exercise of the executive power of the union or the state shall be expressed to be made by the president or by the governor of the state, as the case may be, and all such contracts and all assurances of property made in the exercise of their power shall be executed on behalf of the president or the governor by such persons and in such manner as he may direct or authorize. Neither the president nor the governor shall be personally liable. We skip that for a moment. So blacklisting flows from 298, the right of the state to enter into contract. I mean, 298 is the right of the state to enter into a contract, and to debar is also under is also under 298. This is a constitutional right giving. It's not under any other law. It's a constitutional right exercising. May I invite my lord's attention to 19(1)(g). 19(6).
Are you saying that blacklisting flows from 298?
Yes. With respectful submission is answered.
If a person violates,
The power
No.
to blacklist.
Why-
Is not under.
so just for
45.
example, let us take the example of any other authority or any other authority. Here, the authority which is being given under here is the executive power of the union and the state shall vest.
Lordship.
Any other authority.
All authorities which are a state would be amenable to the writ jurisdiction.
Then,
When I am before this honorable
no,
court,
no, being amenable to a jurisdiction is
it
different
is a state.
from the exercising the powers under 298.
Exercising of the powers under 298,
Is completely different. That is another power.
what I am on, my lord, is the power to blacklist directly hits 19(6). The power to blacklist directly hits 19(6). If, I mean, it hits 19(1)(g), if it is not in accordance with 19(6), the honorable court said upheld that the power to blacklist flows from 298. What I am on is blacklisting does not flow from any other law. Because Article 13, if I may kindly invite my lord's attention to Article 13 for a moment.
Where is the judgment? It shows that blacklisting is from 298.
1975, 1 minute. 7. I'll give it a list of it. 7.
Yes. 19?
75. 1 is CC, volume 1,
Yes. Page?
70. May I invite my lord's attention to paragraph 12.
Para?
12.
Yes.
Under Article 298 of the Constitution, the executive power of the Union and the state shall extend to the carrying on of any trade and to the acquisition, holding, and disposal of property and the making of contracts for any purpose. The state can carry on executive function by making a law or without making a law. The exercise of such powers and functions in trade by the state is subject to Part 3 of the Constitution. Article 14 speaks of equality before the law and equal protection of law. Equality of opportunity should apply to matters of public contracts. The state has a right to trade. The state has therefore a duty to observe equality. An ordinary individual can choose not to deal with any person. The government cannot choose to exclude persons by discrimination. The order of blacklisting has the effect of depriving a person of equality of opportunity in the matter of public contract. A person who is on the approved list is unable to enter into the advantageous relations with the government because of the order of blacklisting. The person who has been dealing with the government in a matter of sale and purchase of materials has a legitimate interest or expectation. When the state acts to the prejudice of a person, it has to be supported by legality. The other has been more categorical, but I'm not on that. I would refer to 1986-3.
No, but this
There are laws.
say that 298 is the power which is being exercised for the purpose of blacklisting.
Then may I?
Because here, therefore, the problem which what we are saying is it is overlapping with Article 14.
I am not on 14.
I understand. Your submission is you are not on 14.
I'm not on 14.
You are on your freedom under 19(1)(g),
My lord.
which is subject to reasonable restriction.
Lordship.
And reasonable restriction has to be reasonable to that effect, and it cannot be so reasonable restriction has to flow from law.
Absolutely. That is my point.
How?
It is 19.6, if I may read for a moment.
Mm.
If I may read 19.6
Yeah.
for a moment. That is my case. It has to be a law. It must flow from a law. The tender term clause in a contract is not a law.
No, therefore, if that be so, what do you say about the Supreme Court's or the well-settled principles to that effect that when the government enters into a contract with anybody, it is a purely commercial transaction?
I presume Article 19(1)(g) and blacklisting with 19.6, perhaps Lordship will lay down with. This opening is not there. We have developed this opening. We are addressing the court on this situation. I have not come across with, but I have come across to say that if 19(1)(g) is to be touched, it has to be by a law. I'll play the judge. Now I'm combining.
But 19(1)(g), although it is there, the fundamental right, it is a freedom.
19(1)(g) is a freedom, but
It is a
19.6
freedom.
is a restriction. The restriction by operation of law. Law, Article 13.
No, why do you say it to be restriction by operation of law?
May I read that?
Yes.
May I go to 19.6 for a moment?
Hmm.
Nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of general public reasonable restrictions on the exercise of the right conferred by the subclause, and in particular, nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevents the state from making any law relating to the professional or technical qualification necessary for the practicing of any profession or carrying any occupation, trade, business, or the carrying on the state by corporation owned or controlled by the state of any trade, business, industry, service, whether to the exclusion, complete or partial of citizens or otherwise. There must be a law, and the law is in Article 13. This gives, this is in even in the CCL mirror, or if I take from Ramanadayan Shetty, entail to CCL and onwards also, my lord, this aspect was not discussed. The freedoms. What about my 19(1)(g)? That was not discussed. So tender clauses can be on different, challenge can be on different grounds. But my client is a conflict with a fundamental right, which says in two parts. Yes, I have a freedom. Yes, you can put restrictions. The reasonable restrictions are not wishful thinking of the executive. It must be by way of the law, existing or otherwise. 13 for a moment, Article 13 for a moment. I'm supported by judgments to say so. What I'm making is responsible statement of the Parliament. No, but the way I'm combining it would open a new gateway. And it has to. It has to. Because if I take it the other way, against me for a moment, but not admitting so, that yes, I was blacklisted. All right. I served my tenure. Now I am not a blacklisted person. The stigma attaches to that. Now suppose the Nunmati flyover is to be constructed from Nunmati to this place, the mammoth task. And they would in all wisdom, in the public interest, require that yes, we do not want any person blacklisted in last 10 years. That may not be wrong, because the state would issue a notification. And the notification is a law.
Well, what do you say about uses?
Uses and customs are not to our state.
That is what they are referring
They are
to.
not referring to.
That
they
all
are saying-
other courts, all the other authorities also
They are not
you have
drawing
the
that.
same uses.
That stand on record is it's 50 lakhs, so we are doing that. So you cannot do unless there is a law. As a state, you bring
Uses
it in
will be a law.
to be a law, it has to satisfy the test of Article 13.
And 13 also say uses will be law.
Usages and customs in my more respectful submission, my lord,
Hmm.
are not acts of authority of state. These are in the realm of presumptions based on social conditions. A usage or a custom, as we had learned in our law school days, my lord, there's a field and a person's walk across the field, they do not take it, otherwise they diagonally they use it. And over a period of time, a path is created and some stalls to come over, some rights are created. So by custom, by usage, this is followed. In the other way, there may be negative customs. Example, sati. Girls were burned, alive, in names of custom. Until the act came, a law to curve it down. There are customs, positive and negative. I would not even go to that address to whether blacklisting is positive or negative, but customs and usages do not bind themselves to the authorities of the state, be it center or the parliament has nothing to do with it. The honorable president and honorable governor has nothing to do with it. So promulgation would not come in. The ordinances do not flow from that. Necessarily, to bring this home, a tender clause cannot debar me by taking note of the earlier blacklisting of me, which has the period is over. They have shown that honorable Guwahati High Court or Meghalaya High Court, the RBI have issued that, but those were not on the challenge. This is a case, you know.
So then what stops you from challenging that if I am blacklisted?
I am not.
No,
even,
I'm saying just say I am blacklisted, then also I can be participating.
That
Forget
is the
about the period after black.
that during the operation of the period of blacklisting,
Why
I
can't
cannot
I?
participate.
Why?
I cannot participate. I'm blacklisted.
No, that is also no law.
So far as blacklisting is concerned, it has the protection of Article 298. Therefore,
How?
I can read from the judgment for that. Blacklisting is protected.
No.
They are invoking a state clause.
No. 298 may give a power. Let's assume it gives a power. It is the action of blacklisting which has happened.
And
Then if
over.
that be so, why can't that period be extended to this period
It
for
cannot
10
be.
years?
It cannot be for a particular
Why?
reason. An order of blacklisting does not operate for end of time. It is limited on the doctrine of proportionality as found up, not on the doctrine of reasonableness. Proportionality. It may be
So
the first
again, if you bring proportionality, you are
Proportionality.
overlapping Article 14.
40 can no. So far as the may not with respect, so far as proportionality is concerned, it would come to the realm of Article 14. If I challenge it is disproportionate, I'm not even on it. I take down with a bow that I was blacklisted correctly and I've suffered my whatever wrongdoings I've done, if may be. But once it is over, you can certainly blacklist me again. But you cannot debar me by a tender clause. There has to be a law to debar.
No.
May
They
I?
may be saying that yes, if you are blacklisted out there for a period of, that is why apply the same rationality. In the blacklisting, if it is done, it is on the basis of an executive order. Some order is passed.
Correct.
Maybe in
Agree.
exercise of 298,
I
it has
agree.
been done,
I agree.
but it is being done.
Agree.
And if that be so, if a blacklisting cannot be permitted, then so why not the 10 years from blacklisting?
Blacklisting can
No.
very well be permitted, Bill. What I'm on is, if I could rephrase my submissions, Bill, a blacklisting is permitted. In the cases where an order of blacklisting is put to challenge, it is only the preconditions and the manner and the soundness of the decision which is challenged, nothing more. Now, I am not on this challenge. And clause, a tender clause, by umpteen judgments of this apex court, restricts
No,
intervention of this
let
honorable
us
court.
therefore assume that the tender clause says that if you are blacklisted, you would not be allowed to participate.
This debarment
That
is
is
not
also
blacklisting.
an order of blacklisting
This-
is not a law.
This tender clause is not blacklisting. It touches upon the law of 1906, which it does not qualify. This is not blacklisting. Put me to notice. and see that.
Therefore, no. Therefore, the restriction which is being imposed upon you is reasonable or not has to be seen as to whether the 10 years would be reasonable or a person who have been blacklisted and for the last 10 years whether it would be reasonable or not, that is the touchstone on which one has to decide.
Precisely. But this is when they qualify on 13 and 1906. Their judgments to show that my protection under 1906 cannot be curtailed by anything but by law.
No, if that be so, the same applies. Blacklisting.
Blacklisting challenge is on a different campus altogether.
No, that is why I'm saying, let us assume the term of the contract says that a person who is blacklisted, he would not be
That is
permitted.
currently. If the person who is blacklisted would be in
Currently,
Currently.
would not be permitted.
Yes, correct.
Then
If
what
a
is
person
wrong?
is currently blacklisted, he
then
does
it
not
will
have the
the same
jurisdiction.
apply. Same principle will apply
may
what
not
you are
be.
saying, because that is
It-
also not a law.
It may not. It may not. The order of blacklisting has a sanctity. It has a legal sanctity. It is not something like written on a piece of paper.
Because your submission, what it flows is restriction has to be by operation of law.
Blacklisting is permissible. Therefore, the
If
judgment.
blacklisting is permissible. I'm not on the blacklisting
not.
question whether it is permissible or not. I'm not. But the term of blacklisting, would it be a restriction? And if it is a restriction, isn't it on the basis of an order? Which
If-
would obviously not fit within the ambit of law
It would.
in terms of section
Article 13, if I may
13.
read, Article 13, if I may read, the order of blacklisting would fall as an order.
No,
May I read?
to me.
May I read?
Yes.
Laws inconsistent with or in derogation of the fundamental rights. All laws enforced in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. 2. The state shall not make law which takes away or bridges the rights conferred by this part, and by any law making contravention of this clause shall, to the extent of the contravention, be void. 3. In this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of. Pausing for a moment. An order issued by an authority is an order which is a law under Article 13. But
No,
a tender clause would
that
not
is
amount
too
to
much.
law.
that is too much. That is too much of stretching. There's an authority passing an order. Or just for example, you are appealing for whom?
IIT.
IIT. IIT passing an order of blacklisting you would be a law within the meaning of Article 13.
I
That is
am
too
on
much.
the action. Well, I will place the judgment. I'll place the judgment. The action is permitted in this country by judicial pronouncements touching upon Article 298. So far as blacklisting is concerned, only the procedural requirements would be a concern of judicial
Mr.
review.
Manik, this court only finds it. If we are applying 19(1)(g), it has to be a reasonable. You can only stop him by way of reasonable instruction.
May I read below that?
And the reasonable restrictions in there, one has to say that whether the term concerned, whether it would be reasonable. That's all.
My lordship, so far as this aspect is concerned, this is not a clause on commercial issues. This is a clause directly
It's a-
on my right to
it's-
participate.
It's actually
It divides a person who's qualified.
No, the state, when it enters into an comes into the trade, you see the judgment of Peter Isaac and all, Supreme Court makes it clear that the government comes and within the ambit of a commercial.
But in most
transaction.
respectful submission, ma'am, this issue was not considered in those judgment. The inconsistency, the conflict when a freedom and a law under 298 they come in. The effect of that clause is that I am debarred from participation. This itself is blacklisting. If that be so, I ought to have been put to notice. But what I am on is, you cannot even put it by tender clause. You bring out a notification, you're a body, you bring a regulation, like the RBI. Very well. You bring a regulation, we'll challenge that if need be. Then go have a tender. They did not do that. RBI can bring out a regulation. No difficulty with. The states can bring out a notification. No difficulty with. The parliaments, when not in session, the ordinances can come. No difficulty. They do not choose to do that. Now they take a different path. They put in a clause, tender clause, and say so for 10 years. If you are blacklisted, they cannot. And more so, in the same tender document, they have contradictory clauses. In one clause, they say whether you are currently blacklisted, and the other one they say for 10 years. That is on the facts of the matter. We'll address that line below. Some other day, I'll place everything in I place what lines I'm on. I'll develop it, on the level of blacklisting vis-a-vis the other countries, how they look into it. This is huge. If this power is given, it's huge power given to them. Once blacklisted forever, anytime. The reasonableness article on the argument would be addressed, certainly.
Therefore, this court can very well look into this aspect
Right.
as to whether after blacklisting, his
Gotcha.
period is over.
Gotcha.
To further extend for another 7 years,
Gotcha.
would that be a reasonable?
Very well. I get it.
That would that be a reasonable restriction to the freedom which a person has under 19(1)(g?
Very well.
That is another aspect.
That is another aspect. That we
In
have
fact,
taken.
that is what I referred to you on the last occasion.
We have
also.
taken that. We have taken that.
But to say that the restriction has to be a law.
It cannot be by a tender clause. It can be by a regulation, notification, order, whatever they do, they can do.
No, because no, the restriction has to be a law.
Restriction
That
has
would
to be.
that
well,
would be too far fetched.
Well, this would be directly on 86.3 SCC 615 by J. Emmanuel. Fundamental rights, freedom 19(1)(g, it has to be a law. I'll place judgments on that,
The restriction has to be a law.
It has to be a law. What I was on, the authorities calling from tender, the authors who are so protected by the judgments of the apex court, cannot touch upon my fundamental right under 19(1)(g. They can bring out a regulation. I would have nothing to say. It operates as a law. The state, if it comes in, is the body. They can come up with regulation. They cannot issue a notification with it. Ordinance will not come in their way. The state may have a notification with it. Has nothing to do. It will come. It's a law. It's an operation. Under that, they may have a clause. But directly to have a clause to debar me, that debarment power is not given to them. I'll place the judgment. Could we have another day? Because we'll place. Elaborate on that.
So the two questions which is there, which I would like to be addressed, as to whether it would be a law. Or restrictions under 19(1)(g has to be a law. And secondly, the power of the tendering authority, taking into account that the tendering authority comes within the state when it enters into a contract, comes within the ambit of a commercial transaction. Is it required to exercise the powers of judicial review in respect to the exercise of powers made by them for framing the terms of the contract? There might be many things wherein there are many judgments by which when the terms of the contract can be interfered with. Because both has to go together.
Both are supposed to
Yeah, together. Because one interference is permissible, provided it is not reasonable. And it cannot be a restriction within the purview of a reasonable restriction as contemplated under 9.
I tried
So that is the bit. Huh?
I tried to reply to my lord's query, but that's the way we did.
Because then one has to see that aspect of the matter. Merely becoming a restriction, becoming a law would not suffice.
I mean, just
It has to be, because what will happen, just for example, a small state authority may not be such a big authority, it's just a small state authority, but it is a state within the meaning of Article 12. They issue a public tender. And they have a similar clause up there. So if that be so, can you say that that term would be, that it would be unreasonable?
it requires a, in my most respectful submission, my lord, it requires a prior notification, notifying that. So once the notification is out, this is law. Now you have a tender. I cannot challenge the tender.
No,
clause
no. Do they
unless
have
that
the power of issuing a notification?
notification flows from the umpteen authorities while clearing the legal angles for that.
No, no, no. Understood. The notification is given by the state, it is a different thing. But here,
It can
when
be
the
an order.
state enters into a contract, or the IIT here enters into a contract with another person or calls for a tender, it informs the authorities concerned, the inviting bidders, that look here, the 10 years out there, you are not to be invited. Wouldn't that constitute a notification for them?
For IIT,
And being a
notification
term of
would
the
not come
tender.
in, my lord. For IIT, a regulation would come. Notification not within the ambit of IIT.
Why is it required? Because they are issuing a tender.
This is an invitation to offer, my lord. The notice becomes an invitation to offer with the mandatory terms therein, which I would not be able to challenge unless I say you did not do the thing in accordance with the Constitution of India. I'm not even on the state acts and rules or bylaws or regulations or orders. I say the Constitution of India demands and mandate that this is the way it is to be done. Does it? I mean, it is done in a particular way. It has to be done that way or not way at all. There's no other way from to escape from that. I'll build up the dialogue. Lordship put it 18th of December, if my lord is there. Part
No.
He will part with.
Lordship, petitioner was blacklisted up till 2015, and thereafter also he was allowed to participate in other tender process. He was even awarded the tender, tender lordship. He was
But in
awarded
those, there were no terms.
no term because of the lesser amount. Because this particular tender process is valued a higher
Understood.
amount.
If it is, you are saying here that if it is more than 50 lakhs, then you are doing it.
Yes, Lord.
But if it is less than 50 lakhs, you are not.
No, Lord.
Now, as regards this, he had challenged this term. Now, whether there is a stay,
Yes,
now what is happening to the stay?
they have not gone ahead with it.
Huh?
Neither filed for vacating of that, nor
You have filed for vacating.
No, Lord. Will not file it.
Then what has happened to the tender?
It was solved. Lord.
Now, you want those goods. The tender.
Perhaps that I have to take instruction from my.
Obtain your instructions. We decide on this bigger question, but we vacate the order so that you can go ahead.
Yes, Lord.
But tomorrow, you just get that instruction.
Yes.
As to you want to go ahead or not. If you want to go ahead, I vacate that interim order, you go ahead. You hear the larger questions. It's the matter tomorrow at 2. You
Okay.
just get that instruction.
At two, Lordship.
Only that instruction. You want to go ahead with.
They have their own constitution. They are registered under the society registry. And Lordship, what has happened? Their last, the NF Railway have provided the OBC FP association certain facilities. So our association has been recognized and we have been granted with the facilities since long. Our last list of elected office bearers is dated 6/8/2019. That is at page 79.
Of which petition?
Petition 8/27/21, item 6.
Yes.
Page 79. This is our last list of elected office bearers. The tenure is from 2019 to 21. Now, Lordship, during the existence of this list of elected office bearers, the impugn order was issued. Impugn order, Lordship, will find at page 94.
Page 90?
94. I'm reading the impugn order, Lord. Kindly refer to your letter under reference. Lordship, this letter is issued by the Railway Board to the President of All India Body. There is an All India Body also. We have no connection with them otherwise. They are separate body, own constitution. Everything is there. And this letter is communicated to us by the next letter, page 95. Now, I am reading 94, Lordship. 94, kindly refer to your letter under reference requesting to withdraw all the facilities extended to illegal zonal OBC association circulated on the request and approval of Sri S. Ramachandra Rao and G. Prasad in the capacity of General Secretary and President of All India OBC Bar Association from 16 to 20. The decision of the board has already been conveyed by board letter event number 6/10/20 regarding regulation of all the list of elected office bearers submitted by Sri Dhruv Yadav and General Secretary for the period 16-18 and recognize Sri Virendra Singh as General Secretary for the period 17 to 19. Therefore, this is relevant, Lordship. Therefore, the list of elected office bearers of zonal associations approved recommended by any other CEC member apart from those circulated by the board by their letter dated 6/10/20 for circulation by the zonal railways would be null and void. Now, this has been communicated to me by the next page, Lordship. Next letter, 95. Subject, Lordship, will see withdrawal of all the facilities extended to illegal zonal OBC association circulated on the request and approval of Sri Ramachandra Rao, Sri G. Prasad in the capacity of General Secretary, President of All India Association from 16 to 20. Now, thereafter, I had approached this Honorable Court. Honorable Court has protected me by granting status quo with regard to my facility. So, we were continuing since then, Lordship, in the office with all the facilities and all. Now, Lordship, this before expiry of this period of 19 to 21, we conducted press election. So fresh election was conducted. The fresh list of elected office bearers was also communicated to the railway authorities for circulation. Now, there are two railway boards circular which I am relying upon, which says that the body has to submit conduct election and submit the list of elected office bearers to the railway administration, and it is the duty incumbent on them to circulate the list. So they have not circulated. So I have filed a second writ petition for circulation because the term was already over before expiry of term press election. Press list is now pending before the railway administration. Now difficulty is that, Lordship, I had also filed one RTI application in order to know whether any other list is also pending with the railway administration. They replied no other list is pending, and the last list is also relates to me. That is, my list was the last list, and the now pending list with the railway is also mine. So it is their duty to circulate my new list of elected office bearers. Now, what has happened, Lordship? They have filed in the second writ petition, item number 7, respondents have filed. Even in the first writ petition, both the respondents have filed a reply stating that their reply is a mistake. So actually, another group has submitted a list of elected office bearers claiming to be the genuine list of elected office bearers. So my humble submission is that, Lordship, although I had challenged the impugn order for certain grounds, I can espouse those grounds. But Lordship, now, Lordship, my humble submission would be that, Lordship, as per the situation as exists today, 2 lists are there, Lordship. So my humble submission is that DM may take a decision in this regard. If, Lordship, that decision is amenable to judicial review, Lordship, either of the group may come for judicial review before the.
Who is appealing for the other group?
Other group, Lordship.
He has not made party.
No. My case was against withdrawal of my facilities, and against that we have come. My case was that
No, the railways recognize only one group.
One board.
the railways said that they are not recognizing you, but they are recognizing somebody else. They are recognizing somebody else, as is apparent from 22/12/2020.
No, Lordship, that is in respect of all India body. There is an all India body. They say that the CEC of the all India body, which is the favorite body of the railway, if that body doesn't give me approval, then my zonal, my NF Railway OBC Association's zonal list is null and void. But my case is that, Lordship, all India body's approval is not at all required, Lordship. Joint signature and approval of the General Secretary and President of All India body is not at all required, because we are independent body. We have our separate constitution, separate registration. That is in fact explicit in their own circular, Lordship. That their approval.
When were you established?
Established, Lordship, my recognition letter that I have enclosed, page 21.
No. Where? I'm asking you, when were you established?
We were registered on 26/2/1999. 26/2/1999. And above all, Lordship, railway cannot at all interfere in the internal matters of the association, Lordship. Our election, our everything.
Then why are you asking them to recognize you?
No, we are not. It is their own circular.
No, why have you filed the second one?
Second one only for circulation. Our list is okay, Lordship. We have.
Then you should not be bothered what they do.
So that everybody gets to know that we are the list of elected office bearers, so that all the authorities grant us the facilities, including all the designated employees of the railways grant us the facilities, including pass, rooms, computers, everything. So it is only for the purpose of circulation.
Yes, Mr. Das. What is your basis? Why do you have to grant the recognition?
Malord, recognition is as per their circular, Malord. We have to page 30 of the petition.
Right?
Page 30, Malord. Let's circulate only on the member. Page 30, 10 election procedure, 10 B, Malord. Circulated can only be a member. But there is a duty for circulation, Malord. So far the election is concerned.
Yes.
And so far,
For the federation shall be held through a secret ballot for selecting office bearers of the federation. You, the maximum procedure is all. Who has done this?
If I may
this
clarify,
is
Lordship,
their circular.
Constitution of the
Yes.
Federation of All India
Yes, yes.
Other Backward
They are
Classes.
They are
Railway
affiliated to this.
This, you have nothing to do with this, no? All India.
no.
No,
My
they are nothing to do with
My
this.
constitution, page 96. My constitution is separate.
But they are the
No, why you are referring to this constitution?
Malad, this is they are under this Malad constitution actually.
No, on
All
what?
India.
No. Are you saying
Yes.
that the railway makes recognition on the basis of somebody else's constitution?
No, they are Malad. Actually, they are under the All India OBC. This petition as Malad.
They say they have nothing to do.
They are the sister concern, Malad.
No.
They are the sister concern.
So let us see your constitution,
96.
page.
96. And we already have recognition, Lordship, page 21.
We will look into that. First 96.
96.
Yeah.
Only the name is NF Railway OPC Employees Association. Because we are in the NF Railway employees are there. Only the name is NF Railway OPC Employees Association. This is our constitution. Process of election is there. Page 97, para 9, process of election. Central committee members of the association shall be elected by secret ballot by the members of the association for a period of 2 years, and election will be held along with the biennial general body meeting at the end of 2 years. Duties of office bearers. It is comprehensive, Lord. we have our separate registration certificate also.
No, understood. That is understood. I've seen it. It's a simple association. It's a society having their own rules and regulations. Now, are you an affiliated member
Yes.
of any of these associations?
Yes. The All India body, we had taken their affiliate,
Whose?
the All India body.
On which one?
The-
All India?
The earlier constitution, your lord.
No, which you are the affiliated body of this.
No,
All India Other
Yes.
Backward Classes Railway Employees Federations.
we are NF Railway OBC Employees Association.
Understood. Are you affiliated with All India Other Backward Classes Railway Employees Association?
Yes, sir. We had taken their affiliate.
Yes, sir. Now, do they recognize you as their affiliated unit?
Yes.
Where is it?
Page 38. Although it has no bearing, but para 1. It has no bearing otherwise. It has otherwise no bearing. Lordship, we are completely.
It's okay. Who is the general secretary of your association?
My general secretary is VP Ramarao. VP Ramarao, Lordship will find his name at page 79. General Secretary VP Ramarao. Even in the second list of elected office bearers, he is again elected as the General Secretary. List is at page 80.
Now, whether your association
Yes.
with that Ramarao
Yes.
is being recognized by the All India organization?
That is the affiliation, Lord.
As it
Oh,
is it recognized?
The list. My case is it is not required.
No, I'm not on that. Is it recognized by that unit having
The present list of elected office bearers sitting in the All India, they have not approved.
they have not approved
And
yours?
Yes. And presently I have not sought for also for
So
their
now you are no longer affiliated with them.
Lordship may say.
Now, without an affiliation, do they have they given any affiliation to anybody else in the NF Railways?
They have given.
Have you made that person a part, that authority a party?
No. Lordship, they had filed one IA for impeachment.
They have filed, or rightly they have filed. But the fact is, why haven't you made them a party?
No,
It is a tussle between you or him as to who is the affiliated unit of the All India body.
But
you have not made the All India body a party. You have not made them a party or anybody.
my case is, Lordship, I do not require the approval or the joint signature of the All India body. That is my first case. And secondly,
No,
second-
are you saying
that is,
that the railway have to give the benefit
Yes.
of recognition to two disputing factions in the NF railway?
railway has already granted recognition. Now it is
The
they-
railways have given recognition to one person who has affiliated and being recognized by the All India body.
they are only to circulate now.
That is it.
Now whether
Just say case, make it very simple.
Yes.
Is that you were once affiliated with that All India body. The All India body was given an affiliation recognition, and in view of their constitution, the railways have given the recognition to the NF railway, your body,
association,
your association. Now there are two different factions of the association, same association, of which one happens to be headed by A and the other happens to be headed by Ramarao. Now they are not giving the recognition to the faction of Ramarao, which you are before this court.
Okay.
Go to the civil court.
Correct, madam.
no, I shall go to the civil.
Their bylaw also says that, my lord, any suit, my lord, 102.
This is between two factions.
Legal
What is
proceeding
there?
No, I shall, but that order, the
Mr.
impute order-
Counsel, understood. The recognition of the railways to the NF Railway OBC Association has not been withdrawn. What they have withdrawn is the recognition of the faction of yours
Yes.
and not his.
Right.
And you have, without challenging his, you are before this court.
Here, Lordship, I am not raising any civil dispute, Lordship. That is my case. My case is only
Mr.
based on
Counsel,
judicial-
no case. It's a case for immediate dismissal.
Lordship, my case is that, Lordship, railway cannot interfere in the internal matters of the association. If they see,
No. Railway, in view of their arrangement with the All India body, grants recognition to the All India body, and on view of the constitution of the All India body, grants recognition to the approved district or the zonal approved body. Now the zonal approved body happens to be someone else and not you.
as on today,
It is a fight between two. It is a fight between two factions.
railway have not approved anybody till now.
Not required. They have given recognition to NF Railway. It remains as it is.
Yes,
as
But
on
it is
20
the
order.
benefit is goes to the person headed by A.
But as on, no, they have not got any benefit. As on today, neither their body is circulated, nor my list of elected office bearers is circulated. So both the papers are on the table of the GM for circulation.
CM will only circulate
One.
those who is being recognized by the All India body.
No, for that, Lordship will kindly come to Lordship, page 186, 186. 186. That is my affidavit in reply. To what extent All India body has power on me? Page 185. First, Lordship, I'll take your Lordship, page 185, running page.
Yes.
Second para.
The matter has been
The
reviewed
matter
in
has
view of the Honorable High Court's Madras of so and so in Iman. Bylaws. The
Cotteshwar
election to
and
the
in
office
time
bearers of so and
bylaws.
so are internal matters of the Federation Iman. The list of elected officials
bear-
followed
followed
by
by-
election so and so is prepared by them and submitted by the General Secretary of the President of Iman for circulation and information for all the railway. The authenticity of such lists can only be authenticated and furnished by the authority from which it has been validated by the Federation by respective.
Now-
to Iman.
Now next page, Lordship.
In terms
Next.
of the board's letter dated Iman, it is hereby declared the approval and joint signature of the President of so and so is not required for circulation. It is advised to circulate the list with better extend the list only to. Yes.
So I do not require All India bodies.
No, whether your elections were conducted as per the bylaws of the association.
That has been certified by the Register of Societies.
Without election.
Yes,
order.
yes.
Whether it is certified or not,
Yes.
I'm not concerned. Whether, because there are two factions
Yes,
having the
sir.
same name. The recognition with NF, The name of the
It-
petitioner remains NF
Yes.
Railway OBC Employees Association. Mr. Das, your recognition to the NF Railway OBC Employees Association still is intact.
Yes, my lord. My lord,
Only thing is that you are recognizing the NF Railway OBC Employees Association headed by so and so,
yes.
No, they are
and not in view of the intervention of the central body
No, no.
stating that we recognize NF Railway OBC Employees Association headed by so and so.
Lordship, they are not saying that, they are
My lord-
recognizing the other list. They are just saying that just two lists are there before us. They're just saying that. They are not saying that the other list is valid, you are not valid.
We are coming to that writ petition secondly. First is first. 827 is on that. It is a fight between two factions of the same association.
No,
Yes.
in the impugn order here at page 94, they do not talk about any other list beyond me existing in the zonal body. They only say that my list is null
Have
and
you
void.
made the All India Association a party?
I do not require their approval. Lord,
Have you made them a party?
No.
What?
because Lordship, first my case is hinges on Lordship.
Mr. Counsel, why do you then require the recognition of the railways?
No, it is already. I only required a circulation.
The railways have recognized this association,
I
but
know
it is headed by whom it is. That is the question.
it is. I
Who is
only-
appearing for Mr. Suresh Kumar?
Last occasion also he did not appear, my lord.
Huh?
This IM lot remain not raised.
No representation
Yes,
and
not been
legal.
And
Anything,
so,
Lord.
so far, my lord, this first writ petition is concerned, this also appears to be influenced by elapse of time. In para 10 of his writ petition, he takes over on 6/8/2019. And period is 2 years. In between, he was suspended. He was suspended on 7/8/2020. And thereafter, pursuant to the honorable court order 23/2/2021, he is continuing. So, in between more than 2 years period over, by elapse of time also, this first writ petition appears to be in first person. Para 10, his last two line, my lord, he admits that 2 years from the date of taking over, sir, still a newly elected and legally valid body takes over, sir. It took over, sir, and functioning with effect from the same day on 6/8/2019. And his suspension order is at page 79, my lord. Robert.
90. What I
And where is 827? What has happened to 827?
827 is pending. Item 6. Item 6, 827 pending. Interim.
And this is the present date petition. Here the interim order is there.
Now, the second list, which you have submitted, have also spent its force.
Then there has been a third election that also I have incorporated in the record with the second.
No. I'm not here. But the second list, for which the second petition was filed,
Yes.
had also spent its force.
Before expiry of that,
How can this go direct now
Tenure is 2
to,
years.
to
Yes.
look into that?
before expiry of that, Lordship, we have again conducted election.
Understood. But as of now,
And
the second list which is given
Yes.
on by letter dated 4/8/2021 have also spent its force.
then Lordship, as on today, Lordship, 2 lists are there. So GM has to take a decision.
No, these are already over.
Okay, then I assume that Lordship, this writ petition is
Election as per
dismissed.
law.
If this writ petition is dismissed, Lordship, then there will be no list of elected office bearers. Then there will be no, because that list is also not certain.
When have you submitted that?
The-
The last election, when was it held?
Last election, Lordship, last election was held on 30/7/23. That is in the second.
And have you forwarded it?
Yes.
When?
We have not received that.
Lordship, that is on record in the second writ petition, page 72. Page 72, I have brought it by way of an additional affidavit, Lordship, page 72. Page 72.
It does not contain this one.
Lordship,
Page Annexure 1.
Lordship.
Annexure 1, page 72
Yes,
of the additional affidavit of the affidavit filed.
yes, Annexure 1.
Additional affidavit.
It contains their receipt seal. Page 73, they have received it.
Obviously.
70,
Okay, the thing is this. You see, no effective writ can be passed here
yes,
in view of this.
yes.
But I dispose of these two and direct the respondent authorities to take a decision on this particular list which have been given. So nothing remains now.
Yes.
In fact,
and till then, Lordship, the existing body shall occupy the, because seat cannot remain vacant. The position, till then the existing.
no, first of all, you have obtained the status quo order without making the other faction a party.
No, Lordship, at that point of time,
There was. Are you saying that there was no other option? The faction. There was a faction.
Yes.
Yes, 100%.
That is
The
why-
All India body have recognized one faction, and that is why that order was passed 22/10/2022-21, stating inter alia that look here, we are only recognizing those factions which have been certified by the All India body.
my claim was not against them. I was in the.
Your claim is not that. It is a claim that the same person, Northeast, not other backward classes employees association.
No, my
Isn't
claim-
that, madam?
My lord, in page number 66 of second writ petition, my lord,
80?
66, 66, my lord.
Yes.
Here, my lord, it is letter from Joint Director Railway Board, my lord, the last line. However, it was advised to circulate the list of elected office bearer of AIO, BCRE and extend the facility only to those members whose election were conducted in accordance with the bylaws of the association.
That observation may be
Yes,
taken.
yes, ma'am. That observation is there,
If
that
it
is
is as per elect.
bylaws of that association, my lord. That is under
No,
the,
therefore, what is happening out here is that there being two factions of the same association.
Yes.
One association, they will also hold it as per them, and they will also hold it as per them. Therefore, it is actually a matter which is to be decided who is the
Yes,
actual
madam.
authority
yes, my
by
lord.
the civil court.
Civil
Lordship,
court, yes.
who will
This is the
determine-
condition of
Yes,
their
yes, my
constitution
lord.
also. And this is the condition of their constitution also, my lord. My lord, 102. And that clause 102, legal proceeding, suit, my.
that was my initial submission. If the general manager circulates one of the list, Lordship, other list will go to the civil court.
But in the meantime, other group may not know.
He will circulate it. If the general manager circulates one of,
Understood, but why haven't you made the other faction a party?
because I have approached the judicial review because Lordship, my case.
No, you are review without making them a necessary person. Can this court today direct? That is the problem which has happened when the status quo has been given. Now There is a party who has the one faction of the same name who is being recognized by the central authority, and they have also recognized them.
Lordship,
And because of the status quo, they are also giving you the facility.
Lordship will kindly see the prayer, Lordship. I had appeared on the behalf of the association. My prayer
Understood.
not
I'm not saying that you are not appearing on behalf of the association, but the association has two factions. Are you denying to that fact?
I was just saying that you do not interfere in our internal matters. We'll sort it out. That was my
Of whichever?
Lordship. The
Internal matters of what?
our own
So don't recognize anybody. We pass that here. Don't recognize anybody.
Repeatedly, that is the argument, madam.
Then don't apply, give anybody. I think that is the best.
then that will affect their own circular.
That won't affect their own circular. Their circular would be always subject to the orders passed by this court. So don't give anybody any benefit.
Then they will circulate the appropriate list as your Lordship it has appropriately fallen from them. I was just praying that till then the existing, because Constitution says
I am not, because this court ought not to have passed that order at all of status quo.
and then Lordship will the Constitution para 24 just for a moment, Lordship. Then Lordship will pass order.
Page?
Page 101, page writ petition 827. Page 101. My Constitution, Lord, our Constitution.
Yes.
The office bearers, para 24. The office bearers will have to resign from their respective posts in the biennial meeting, but they may be eligible for re-election. The office bearers resign in a general meeting shall not be deemed to have vacated the respective office until their successors are elected.
Then?
Until the successors take charge.
Successor already elected, but could not.
As of now, you have a new list.
Yes.
Then
Yeah.
how does this clause comes in?
Okay, then. Much obliged. Much
Both the writ petitions are taken up for disposal by this common order. From a perusal of the materials on record, it reveals that the petition association is a society registered under the provisions of the Societies Registration Act 1860. Full stop. The petitioner association has its own set of bylaws. Full stop. It is also an admitted fact that the petitioner association is an affiliated association to the
All India. OBC Railway.
All India OBC Railway Employees Association.
federation.
All India Other Backward Classes Railway Employees Federation. Is affiliated to an association, to a society in the name and style of All India Other Backward Classes Railway Employees Federation. The said All India Other Backward Classes Railway Employees Federation is also, which is also a society registered under the provisions of the Societies Registration Act 1860, has its own set of bylaws. It is also an admitted fact that the All India OBC Railway Employees Federation is recognized by the Railway Administration. And on the basis of such recognition, the affiliated units of All India OBC Railway Employees Federation are also granted recognition and benefits. The petitioner herein, which is an affiliated unit of the All India Federation, All India OBC Railway Employees Federation, have filed the instant writ petition being agreed by the communication dated 22/12/2020 issued by the Joint Director Establishment bracket RES Railway Board. Wherein it was opined, we stated that the list of elected office bearers of zonal associations approved or recommended by any other CEC member bracket apart from those circulated by the board by its letter dated 6/10/2020 bracket close for circulation by the zonal railways would be null and void. On the basis of the said circular communication, the petitioner association headed by under the petitioner association, wherein with the general secretary, with Sri VP Ramarao as the general secretary, was deprived of the facilities extended in view of the request and approval of Sri S. Ramachandra Rao and Sri G. Prasad in the capacity of the General Secretary and President of the All India OBC Registered Employees Federation for the year 2016 to 2020. It is on the same basis that WPC number 827/2021 was filed. The record reveals that this court, by an order dated 23/2/2021, issued notice and directed status quo be maintained in respect of the possession of the official facility till the next date. It further reveals from the records, and more particularly the bylaws of the Petitioner Association, that the term of office of the office bearer is for 2 years. Under such circumstances, the Petitioner Association, under such circumstances, it is the further case of the Petitioner Association that on 24th of when was the election held?
Latest lordship.
The earlier one?
Second one, page 19, second writ petition.
When? What is the date?
Letter is dated 4/8/21. Date not
Was held in the month of August 2021. And a communication was issued on 4/8/2021 by the newly elected elected executive committee, by newly elected officials of the Petitioner Association to the General Manager, oblique Production Chief, what is PR?
principal.
A Principal Chief Personnel Officer, NF Railway, Maligaon, on 4/8/2021. for circulating for extending all facilities to the newly elected Zonal Executive Committee of the Petitioner Association. However, as no steps were taken, on 22/10/2000, what is the date? 21.
Yes.
Another communication was issued to the General Manager and PCPO of the NF Railway. Requesting that the elected list be circulated to all concerned by the railways so far. Be circulated by the railways. It is the further case of the petitioners that in spite of those communications, the list was not circulated, for which the second petition was filed, being WPC number 3601/2022. It is further relevant to take note of a further subsequent event which had taken place subsequent to the filing of the writ petition of the executive of the Petitioner Association, which was held in the month of August 2021, also expired. And a newly elected and new elected office bearers of the Zonal Executive Committee of the Petitioner was held
Election 38, election on 37/20.
on 37/2023. For the period 2023 to 2025. And in that regard, a communication was issued on 14/8/2023 intimating the General Manager, NF Railway, Maligaon, to extend all facilities to the newly Zonal Executive Committee members. This court further finds it relevant, further finds it relevant to take note of the affidavit filed by the respondent numbers 1, 2, and 3 in WPC number 3601/2022, wherein it has been mentioned that by the letter dated 6/8/2019, necessary facilities were provided to the office bearers of the NF Railway OBC Employees Association as per the Railway Board's extant norms. It was also mentioned that the Executive Committee of the NF Railway OBC Employees Association, Maligaon, have been approved and recommended by the All India OBC Railway Employees Federation, New Delhi, for circulation. Further to that, it has been mentioned that the term of the office of the said Zonal Executive Committee of NF Railway OBC Employees Association was for a period of 2 years from the date of taking over the charge by the newly elected body. And the term was completed on 5/8/2021. It was further mentioned that by the communication dated 22/12/2020 of the Railway Board, facilities extended to illegal zonal OBC associations were withdrawn on the request and approval of the General Secretary and President of All India OBC, what is that? Railway Employees Federation for the year 2016-2020. The said Railway Board's letter dated 22/12/2020 was issued in reference to All India Other Backward Caste Federations letter dated 1/11/2020. Further to that, it has been mentioned that in view of the order dated 23/2/2021, directing the maintenance of status quo, no steps could be taken as regards the circulation of the circulation by the railways Further to that, at paragraph number 12, it has been mentioned that 2 different lists have been received from 2 groups requesting for circulation, and the matter could not attain finality due to status quo granted in WPC number 827/2021 by order dated 23/2/2021 and puts. In the backdrop of the above facts, this court have also duly considered the submissions made by the learned counsels for the parties. From the perusal of the materials on record and after hearing the learned counsels for the parties, it appears that the NF Railway OBC Employees Association is a recognized affiliated unit of the All India OBC Railways Employees Federation. It further reveals from the materials that there are internal disputes as to who is the executive committee, actual executive committee of the NF Railway OBC Employees Association. At the request of the General Secretary and the President of All India OBC Railways Employees Federation, the impugned communication dated 22/10/12/2020 was issued whereby the recognition of various unauthorized OBC, zonal OBC organizations were withheld, were taken, were de-recognized, whereby whereby various unauthorized OBC zonal zonal OBC associations were made null and void. Therefore, the issue involved in the instant writ petition is as to which faction of NF Railway OBC Employees Association is the actual executive body of the said association. However, it is relevant to take note of that in the instant writ petition, the rival faction, neither the rival faction nor the All India OBC Railway Employees Federation have been made parties. On this ground alone, both the writ petitions ought to be dismissed. No, on this had not been made party. The above, therefore, would show that the fact who is the owner, who is the actual authority, executive of the NF Railway OBC Employees Association is a question of dispute which cannot be adjudicated in a writ proceedings. For which the executive body of the petitioner further to that, without the presence of the All India organization, All India OBC Railway Employees Federation, and the rivals faction, who also claims to be controlling the NF Railway OBC Employees Association being made parties, no effective writ can be issued. Be that as it may, it is, however, relevant to take note of that both the executive bodies for the period from 19 to 21 and 21 to 23 is no longer functioning. Both the executive bodies of the petitioner both the be that as it may, it is relevant to mention that the executive body of the petitioner for the period 19 to 2020, 2019 to 2021, and from the period and from 2021 to 23 is no longer functioning, and on 2023, a new body have been constituted. And in that regard, a communication have already been sent to the general manager, NF Railway. As could be seen from Annexure 1 to the additional affidavit filed by the petitioner on 16/8/2023 in WPC number 3601/2022. Taking into account that this court is not in a position to decide the dispute on account of disputed questions of facts, as well as on the account of the necessary parties being brought on record, this court disposes both the writ petitions, directing the general manager, NF Railway, to decide to take a call on the said application, on the said representation, on the said communication dated 14/8/2023 forwarded by the petitioner. And if on account of complicated disputed questions of law and facts arises, the general manager, NF Railway, Maligaon, would be at liberty to direct the respondent of the said petitioner to approach the appropriate forum. With the above the instant petition, both the petitions stands disposed.
Much obliged.
Item number 28.
May I please? Matter related to settlement of market by the municipal board, my lord. Here, my lord, the Mangondawai Municipal Board by NIT dated 1/2/2023, 27/1/2023 invited tender for settlement of Mahaloi Fish Market, my lord, for the period 2023-24. With effect from 1/4/2023 to 30/3/2024. Accordingly, my lord, 4 tenders submitted tenders for settlement of the fish market, including petitioner, my lord.
Where is the tender notice
Tender notice, my lord, at page 21, my lord.
for settlement of Hats and Bazaar?
Bazaar.
Okay. Then
Then, my lord,
you
person that-
submitted.
yes, 4 tenders submitted tender, my lord.
Okay.
First, my lord, Himangshu, my lord, Sarkar, my lord, who is the petitioner here, he submitted his tender putting bid value of 15,84,000. Second, Joiram Shahar Bharali, 14,45,301. Then third, Jagadish Rajbangshi, he submitted 9,04,444. He is a private respondent here. Third, fourth, Ganesh Sarkar, he submitted 8,83,334.
Where are you?
I am first one, L1. Himangshu Sarkar.
Oh, Himangshu Sarkar.
Sarkar, my lord.
Okay.
Yeah. Thereafter, my lord,
It has been given to whom?
third one, my lord, private respondent, 9,04,444.
Why?
By losing 6,79,551, 56 rupees.
Yes, why have you given?
I have the record, Lord. I have the record.
Understood. You must have gone through the records. Why have you given?
He has not submitted GST certificate, Lord. He has not submitted GST.
He has not submitted
GST certificate, Lord.
GST.
Lord.
Where is it required?
Yes.
That is page 25, Lord. This is vernacular.
Page 25.
নিবেদনকারী জামিনদারের জিএসটি আর আয়কর মুক্ত প্রমাণপত্র দাখিল করব লাগিব। পেজ 25 খ হলো।
Page 25.
Page 25. Clause.
Second clause.
Huh?
খ।
So he requires a GST and income tax clearance certificate.
Income tax submitted.
He has submitted the
You have not submitted the GST.
Regarding GST, my lord, I am submitting my lord on
Hmm.
that. Your lords will find at page 33, my lord. That is the impugned decision taken by the municipal board, my lord.
Hmm.
Page 33, below, my lord.
Hmm.
Serial 4. নিবিদাকারী L1 জিএসটি নথি আর কার্যালয়ের সংগৃহীত 500 টাকা রসিদ পোৱা নগল on two ground the receipt of rupees 5,500 and GST has not been found in case of petitioner, my lord. Regarding my lord receipt of rupees 500 clause 1, your lords will find, my lord, at page
Forget about the GST.
GST, my lord, the duration of the petitioner for return of the GST 3 months, my lord. October, November, December, he used to pay in January, and January, February, March, he used to deposit April. The tender submit was date for submission of tender was in the 15 March 2000. So he in that time he was not.
Did you apply for the GST?
He submitted GST, my lord, on April, my lord.
These
For
are
that period.
as per the GST, you have to give quarterly returns.
Yes, yes.
But for the earlier period, did you give it?
Yes, yes, earlier period I have given it. For earlier, January, February, March, for October, November, and December, my lord, I have paid. Your lordship will.
Have you given the GST clearance certificate?
No.
Why? Madam, why should you?
Your lordship will kindly come to page 44, my lord.
Page?
44. 44. Sorry. Come to page 38, my lord. Sorry, 38.
Yeah.
That is, my lord, for the period October to December, my lord, of my lord, period. He has deposited it on 15 January 2023.
Did you submit this?
Yes, thereafter, my lord.
No, did you submit this?
And it is
Not
mistake done
Did
by
you
petitioner, my
submit
lord.
it?
He did not submit it.
No.
He understood that, my lord, that,
I'm not going to look
at the
into
time
it.
of submitting the tender,
No. Did you submit this document?
at the time of submitting tender, it was not submitted.
Okay.
As because because in the tender clause, but it was not stated that you will submit it prior to that period, my lord.
Can't help it.
At that time of submitting the tender, the period for GST was not due. That is why he did not submit it.
It was due for the earlier period. Why didn't you submit the earlier period? I would have understood if you had submitted for till December. If they don't consider and it was not due thereafter till the month of March, and there couldn't have been new fresh return. It would have been, the question is different. But for the earlier period also, why didn't you submit? You had to submit a GST clearance certificate. You didn't submit.
Your lordship will kindly come to page 44, my lord. That is the nature of GST in case of private transfer, my lord. Page 44.
Yes.
It is the GST returned by the petitioner. Private transfer, my lord, for the month of February, my lord. All at 000, my lord. It is the nature of GST, my lord. Only for that, my lord, my lord, the settlement has been given by losing 7 lakhs. Say by rupees 7 lakhs. Petitioner although approached the authority that he at the time of submitting his period was not due, that is why he could not submit it. But he deposited the earlier period. So if authority concerned considered his settlement.
Did you submit it prior?
At that time.
No. So we dismiss it.
It is well curable defect. Well, regarding settlement process, my lord, it is not a defect that it is a fatal defect.
Whether it is curable or not, can this court decide now in view of those judgments of AFCONs and all? Where the authority considers it to be not curable, this court can't sit over that.
In so
The
many cases, my lord,
days of Pudar ties or Pudar steel is no longer there. At that point of time, the question of mandatory or directory was there. G.J. Fernandez, the directory mandatory was there. But nowadays, with those judgments out here, where it clears that it is for the authority. Jagdish Mandal, the Supreme Court says, it is for the authority to decide which one it is, whether they require it or not. And for that, the authorities think it, that this is it. They may lose money for that, but then also they want the GST thing. And for that, can this court hold that it was bad? Very difficult. Mr. Counsel.
In case of some settlement, in some cases, my lord, Honorable Court has also directed to cure the cure the rectification in case in defects in case of my lord which are curable, my lord, defects.
There's no curable. The question of curable or not, they have construed it as mandatory. Can this court sit over it? No, not possible. The judgment. Many judgments are there, Mr. Counsel. Ordinarily, a writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not they accept the bid of the tenderer unless something very gross or palpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set at naught the entire tender process at a stage when the contract is underway would not be enough. The law relating to as observed by this court in Jagdish Mandal, that while invoking the power of judicial review in matters as to tenders or award of contracts, certain special features should be borne in mind. That evaluation of the tenders and awarding of contracts are essentially commercial functions, and principles of equity and natural justice stay there. If the decision relating to the relating to the award of is bona fide and in public interest, court will not interfere by exercising powers of the even if a procedural aberration or the error in assessment or prejudice has been caused to a tenderer. And help it, Mr. Counsel.
My lord, your lord may kindly come to page 27, my lord. Clause 25, my lord.
Yes.
Here, my lord, as per clause 25, my lord, নিবিদাকাৰীয়ে নিবিদাৰ লগত নিবিদাত উল্লেখ কৰা যিকোনো শৰ্ত খিলাপ কৰিলে নিবিদা নাকচ কৰাৰ এখতিয়াৰ পৌৰসভাৰ সভাপতি থাকিব. It is only the power of the chairman, my lord, of municipal board. Here, my lord, the decision has been taken by the board, my lord. On that board, the chairman was absent, my lord. Page 33, my lord.
Page
33.
Yes, what?
Top, my lord, উপস্থিত সদস্যৰ সহি ব্যক্তিসকল নাম্বাৰ 1, my lord, অচ্যুত চন্দ্ৰ দাস, মাননীয় উপসভাপতি মঙলদৈ পৌৰসভা.
So,
vice chairman was not present in that meeting, my lord. As per clause 25, only chairman can do it.
clause 25 of what?
Of NIT. Page 27.
No. In absence of the chairman, the vice chairman can.
Well, here specific term has been given. It is only the power of the chairman. It is also, my lord, mandatory clause, my lord.
No, why should this court interfere on this? But the instant writ petition has been filed by the petitioner challenging the resolution number 1 dated 27/3/2023 and the settlement order dated 31/3/2023 issued by the chairman of the Mongoldoy Municipal Board settling Mongoldoy Fish Market with the respondent number 6 for the period of 2023-24 and direct the Mongoldoi Municipal Board to make the settlement of Mongoldoi Fish Market for the period of 2023-24 with the valid highest bidder, oblique the petitioner forfeit. The facts involved in the instant case, as could be discerned from the materials on record, reveals that a tender notice was issued by the chairperson of Mongoldoi Municipal Board, Dorong, Mongoldoi, for the purpose of settlement of Haat/Bazaar/bus parking, river mohol, etc. under the Mongoldoi Municipal Board for the period 2023-24, subject to fulfillment of the terms and conditions of the tender notice. It further reveals from the records, reveals from the tender notice, more particularly clause 7, that the tenderers were required to enclose various certificates as stipulated therein. It reveals further from the perusal of the comparative statement enclosed to the writ petition as annexure E, that the petitioner herein had submitted the tender of an amount of rupees 15,84,000, whereas the respondent number 6 had submitted a tender of rupees 9,04,444. The second highest bidder was by one Joyram Bhorali, who had quoted rupees 14,45,301. However, the respondent authorities have settled the tender with the respondent number 6, who had quoted rupees 9,04,444. It is further transpired from the minutes of the meeting held on 27/3/2023 that the petitioner's bid was cancelled, was rejected on the ground that he did not submit the GST document as well as the money receipt of rupees 500, whereas the petitioner, the bid of the second highest bidder, that is Sri Joyram Bhorali, was rejected on the ground that he had withdrawn the said bid. It was only, therefore, the third highest bidder, that is the respondent number 6, was awarded the contract. The learned counsel, the petitioner, therefore, being aggrieved by the said resolution adopted in the meeting dated 27/3/2023 and the subsequent communication dated 31/3/2023, whereby the settlement was made in favor of the respondent number 6, have approached this court by filing the instant writ petition, seeking the reliefs as aforestated. This court, having perused the tender document, have perused the tender document, wherein at clause 7, it has been stated that the GST clearance certificate as well as the income tax clearance certificate are to be submitted along with the tender document. Admittedly, the said the said GST clearance certificate was not submitted by the petitioner along with his tender document. The learned counsel, appearing on behalf of the petitioner, had submitted that the said document is that the submission of the said document is not an essential condition of the tender, and as such, the respondent authorities ought to have taken into account that the petitioner had quoted a higher price than what was quoted by the respondent number 6, and accordingly the tender ought to have been awarded to the petitioner. This court have taken note of the judgment of the Supreme Court in the case of Afcons Infrastructure Private Limited versus Nagpur area, reported in 2016 10 SCC so and so wherein the Supreme Court had observed like of the judgment of the Supreme Court in the case of Afcons Infrastructure Limited versus Nagpur Metro Rail Corporation Limited, reported in 2016-16 SCC 818, wherein the Supreme Court at paragraph number 15 had observed that the owner or the employer of the project having authored the tender document is the best person to understand and appreciate its requirement and interpret its documents. It was further observed that the constitutional courts must defer to this understanding and appreciation of the tender documents unless there is a malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. Further to that, the Supreme Court also observed that though it is possible that the owner or the employer of the project may give an interpretation to the tender document that is not acceptable to the Constitutional Court, but that by itself is not a reason for interfering with the interpretation so given. The said proposition was also again reiterated by the Supreme Court in the case of
Ventures Private
Hmm?
Balaji Ventures Private 50%. Maharashtra State Power 2022.
in the case of Galaxy Transport Agencies, contractors, traders, transports and suppliers versus New J.K. Transport Fleet Owners and Transport Contractors and others, reported in 2021-16 SCC 808, wherein also it was observed that the authority that authors the tender document is the best person to understand and appreciate the requirements, and as such, it should not be second-guessed by the court in a judicial review proceedings. Taking into account the above propositions, of law as well settled by the Supreme Court. And also further taking note of that in clause 7 core, it was a requirement that the GST clearance certificate was required to be submitted, which the petitioner admittedly did not submit. This court finds no reasons to interfere with the decision taken on 27/3/2021 in the minutes of the meeting to settle the tender in favor of the respondent number 6, as well as the settlement order dated 31/3/2020, 31/3/2023, 23 or 21, 23, issued by the chairperson, Mongoldoy Municipal Board, thereby issuing the settlement order in favor of the respondent number 6. In that view of the matter, this court finding no merits in the instant writ petition, the instant writ petition stands dismissed.
Number 8.
Revisional.
Yes.
Better part is my lord, settlement of a plot of land, my lord. Then my lord, petitioners have the my lord, had positive plot of land measuring my lord 1 katha 10 less my lord on the village, revenue village under Sundapur revenue circle my lord. Since 1968 my lord, and from 1971 my lord, he had been paying regular taxes. My lord.
What
However, my lord,
taxes?
they
What
calculate some
taxes are you
my lord.
paying?
Toji. Yes. I had annexed those chief my lord. Now my lord, from 2021 my lord, some communications were continued my lord during the lifetime of the petitioner's father my lord, like Mohanlal Sharma my lord. In the year 2009 my lord, the GMT had also allotted settlement my lord. Thereafter my lord, no final settlement has been done. Now my lord, in the year 2022 my lord, the Revenue Circle Authority of the Revenue Circle my lord had vacated the land my lord, demolished the.
They have been demolished, removed,
Yes, sir.
evicted.
Yes.
Now what happens?
Now my lord, petitioner before your lordship my lord, with a prayer for taking the respondent authority to settle the land with the petitioner.
Hmm.
The petitioner's father my lord, since the petitioner's father was a landless person my lord. Now on the last occasion my lord, a lordship has directed my lord to the respondent authority to as to why my lord, whether my lord the petitioner had possessed any government any land in his name or not.
Yes, you are saying out here that the petitioner is not a landless person in your affidavit.
My lord, in my lord, that in an affidavit we have stated, and the lordship may kindly see our affidavit, paragraph 8 also.
I've seen that, but where is that land?
Lordship, paragraph 8, the 420, that land has been, my lord, they have, my lord, the recorded patta on in the state, my lord, the dark number and patta.
Where?
Paragraph 8, lordship.
Where is that affidavit?
Running page number 49.
Right. Family possesses recorded patta land.
And my lord, this is the one Jamabandi copy I have received protect. My lord, it is my lord, that the name is my lord, that land has been allotted Premjit Samadas, son of my lord, that Mohanlal son.
Huh?
Mohanlal, son of Mohanlal son. That land has been my lord.
It has been allotted to whom?
His son, lord.
No, well, that is different.
His brother, my lord, he has been my lord allotted. As because my lord, that land was my lord 383, is my lord has given the industrial land. So my lord, some other portion they have been given. Nearest to the my lord, there are 383.
Premjit Sharma.
Lordship.
420.
420, Your Lordship.
Pata number 53.
53.
Total area of land is 5 bighas, 2 kata, 9 lesser.
There's a given one 1 kata 10 less.
1 kata 10. When was this land allotted?
Lordship in
2022.
2012 or 13. Like,
2012. Have you mentioned this aspect in your
Malad,
petition?
they have never mentioned Malad, regarding that land. Lord.
Huh? Yes, yes.
No, madam. Petitioner's father, my lord, was Mohanlal Sharma, madam.
Mohan Das?
Mohanlal Sharma, petitioner's father, madam.
Yes.
Madam, he had
Does he have a son in the name of Premjit Sharma?
No, madam. Premjit Sharma, madam. Premjit Sharma is his son, madam.
Whose son?
Mohanlal Sharma's son, madam.
Understood. Mohanlal Sharma has his son.
Yes, madam.
Yes. Then?
And he has purchased the land, madam, at his own capacity. That land is separate thing, madam. That land is separate thing. That was purchased probably, madam, by his son, madam. And here is the petitioner before your lordship is Robirup Sharma, madam. The other of Premjit Sharma.
Brother of?
Premjit Sharma. Premjit Sharma, the probably the record of your lordship.
So this land he has purchased.
Yes, sir.
Premjit Sharma has
Yes,
purchased
yes.
from?
I don't know, my lord. I am concerned with only Robirup Sharma and Mohanlal Sharma.
So did you submit an application for settlement?
His father had submitted.
Then?
Then that process is still going on, my lord. Kindly see, my lord, what they are doing, my lord. Page 44, my lord.
Huh?
Page 44. Of my repeat, my lord.
Yes.
My lord, dated 28th of January 2022, my lord. Regarding allotment and settlement of land in favor of late Mohanlal Sharma. Tell my father. My lord, reference here as 67/2001, public 6161. With reference subject cited, I have the honor to request you for your kind order to so as to inform me about the present status of the above referred case in respect of settlement of land in the favor of my father, late Mohanlal Sharma.
So you have not filed any application. Have you been evicted?
Yes, already demolished.
Lordship, my lord, that roadside land we have been evicted. Lordship, my lord, that there is a my lord, that trash map, Lordship,
Where?
in that my mind.
In this one?
And Lordship, the next step. Trash map is there.
Hmm.
And Lordship, the blue marks is given. This is the my lord, that drain.
What is the dark number? 308?
383.
380? 383 now you have cleared it.
Lordship, my lord, that only my lord drain, my lord, they have occupied the drain, my lord,
No,
that drain side. Lordship. This drain, my lord, they have constructed, my lord, that running their shop on. Only my lord, that shop we have been evicted.
Okay, remaining?
Remaining is the
You are in possession of land, Ini.
But that is still vacant by me. That is still vacant. The house.
Are you in possession of land or not?
Yes, yes.
You are still in possessing.
Yes, madam. I am not posing, but the house has been demolished. I am sitting nearby.
Where?
My lord, on the house of Premjit Sharma.
That's brother, Lordship.
No, he's brother, madam. Yeah. That.
Huh?
Satyanarayan Sharma.
Satyanarayan Sharma.
Satyanarayan.
Who is he?
My lord, he is the Mohanlal Sharma's elder brother. Satyapal Sharma.
So you are now not possessing any government land.
No, my. And this land, my lord, has been enjoyed by my father, my lord, since 1968, my lord. 1968.
But anyway, you have no right to claim possession right over that land.
My lord, moreover, the eviction process was driven, my lord, without issuing any notice also.
Why notice is required?
Well, at least 15 days notice, my lord.
Why? Why?
There is a requirement, my lord.
Under what provision?
15 days prior notice, my lord.
Under?
Under Rule 18 of the Assam settlement rules, my lord.
Where? That is a roadside reserve land?
Roadside reserve. But the drain has already been constructed, my lord.
Is it the roadside reserve land?
Roadside land.
So roadside land, how 18.3 will apply? It is a pure case of 18.2. Then where is the 15 days notice?
Well,
Mr. Hawk, what you do is best
lord,
is
uh,
file an
yeah.
application.
my lord, you can file, my lord, but
Huh?
my lord,
Nothing can be done in this.
may,
You've been evicted. You see, now you have to apply as per that, whatever as per the land policy 2019.
my
And if you apply, they
my
will
lord, here, my
consider
lord,
your
my
application.
lord, kindly see, my lord, the point 14.4 of the land policy also, my lord. It's
What?
land policy of 2019, my lord.
What is that?
It's 14.4 my point I'm reading, my lord.
Yes.
However, in view of the land policy 1989 and other government decisions prior to adoption of this land policy, the cases of indigenous landless persons, if found eligible, who have been under continuous occupation of government land since or prior to 28th of June 2001, may be considered for settlement of maximum of 1 katha 5 lessons of land in cases of Guwahati, and 1 katha and 10 lessons in
And
cases
kindly
of
read 14.3.
the state government will not consider settlement of any government land in Guwahati city or in other town areas under possession of individual or other person merely on the ground that the person concerned is in occupation of such land irrespective of the period of such occupation or enforcement. It would be the policy of the state government to consider settlement or to evict such person as the case may be. Well, it is not supporting, but 14.4 is supporting me, madam.
14.4 is not supporting you. 14.4 means you cannot claim a particular right that I have to be settled here. You are a landless person. You want the land, plot of land. That's all.
Well, it also says, my lord, under continuous occupation of government land since or prior to 28 June 2001.
You apply, they will consider as per 14.4, 3, 4, 5, whatever may be, they will consider it. That is the best way. This court can't give you a direction here. I give you a liberty to apply and they will consider, I'll direct them to consider. I think that is the only way out. And that too, your, see the land policy, there is also one term as regards family. Have you seen that? Rule 2. See rule 2 of land policy. Explanation. There's a definition of family. Is there or not? No. Then in your big settlement book, you were referring to rule 18. Let us rely on rules 15 of your settlement rules.
Take 18, take
You are referring to rule
Settlement of-
18.
yes,
See rule 15.
settlement of- yeah, right.
What does he say?
Right.
Hmm?
Preceded by notification, no person shall have any right to settlement merely because he is in occupation of land not included in any lease granted by the state government, either by himself or any other person. But it is substituted by notification. Yes, already earlier it substituted.
What did he say? No person shall have any right to settlement merely because he is in occupation of land not included in any lease granted by the state government either to himself or to any other person. That is it. That,
Right.
that is why you find 14.3. Get it? Okay.
Course of hearing.
I will let me record your submissions. And
Right.
the instant writ petition has been filed by the petitioner, seeking a direction upon the respondent authorities to grant settlement to the petitioner against the plot of land measuring 1 katha 10 lechas covered by DAG number 383 at Revenue Village Bonda under Chandrapur Revenue Circle within the Kamrup Metropolitan District. And further, in the interim, sought that the petitioner should not be evicted from the land under possession. Full stop. The facts of the instant case, as could be seen from the materials on record, is that the petitioner claims that his father, late Mohanlal Sharma, his father, one Mohanlal Sharma, bracket since deceased, was in possession of a plot of land measuring 1 katha 10 lechas covered by DAG number 383 new at Revenue Village, Bonda, under Chandrapur, bracket Panikhati, Revenue Circle, within the, under Moza, Beltola, in Kamrup Metro District. It has been stated that the father of the petitioner was enjoying the possession since 1970 till his death on 21/8/2021. Full stop. It has also been stated that the petitioner's father was also paying revenue. Be that as it may, this court, upon perusal of Annexure A to the writ petition, which the petitioner claims to be revenue-paying receipts, it is seen that the said are payment of penalty for unauthorized use of government land. It is the further case of the petitioner that the petitioner's father, during his lifetime, made an application for settlement of the said land. However, the respondent authorities did not take any steps. On the other hand, the petitioner was threatened to threatened that the petitioner would be evicted from the said land, for which the instant writ petition has been filed seeking the relief as aforestated. This court had issued notice. Now, this court, by an order dated
17/10/2020.
10/3/2022, issued notice and a direction was issued to the Deputy Commissioner, Kamrup Metro Land Settlement Branch, as well as the Circle Officer, Chandrapur Revenue Circle, Panikheti, to place the relevant status of the government land involved in the present case, and also apprise the court as to whether the authority concerned considered the case for settlement of the said government land in the name of the petitioner or his father, and if so, what is the outcome? It reveals from the records that the respondent number 2, that is the Deputy Commissioner, Kamrup Metro, had filed an affidavit in opposition. In the said affidavit in opposition, it has been mentioned that On 5/3/2022, as per the direction of the authority, the Circle Officer Chandrapur Revenue Circle cleared some encroachment on the drain of ASIDC in front of some leased commercial shed owned by the ASIDC, encroachment over footpath, along with some unauthorized construction, temporary bamboo construction and semi-permanent shop, motorcycle repairing sheds, unused under construction shed made with brick and tin shed at Sorkari Dag number 383 at village Bonda by the side of the state highway number 3. It was also communicated, it was also mentioned that the illegal encroachers were also asked to evict themselves from the aforesaid government land. Further to that, it was also mentioned that the petitioner is not a landless person as per the records available. Further to that, it was also it was stated that the petitioner is not living in any of the demolished temporary shed, but using for illegal trading of government land. But it was also mentioned that the petitioner had applied for allotment of the land at Dag number 383 by submitting false documents stating that he has no other land in his name or any family member's name. It was also mentioned that the demolished shed was standing on government land used for commercial purpose and some portion was not at all being used. It was a planned encroachment of the government land. Further to that, in paragraph number 8 of the petition, of the affidavit in opposition, it was mentioned that the petitioner's family possesses recorded patta land covered by Dag number 420 of KP Patta number 53, adjacent to Dag number 383 at village Bonda. This court at this stage also finds it relevant to take note of the submission made by the learned counsel for the petitioner that the petitioner was also evicted from his land, from his possession by the respondent authorities. This court further finds it relevant that an affidavit in reply was filed by the petitioner denying to the contents of the affidavit in opposition filed by the respondent number 2. The record further reveals that pursuant to an order dated 17/10/2023, the record further reveals that on 17/10/2023, this court directed the government of Advocate Assam to produce the record on the basis of which the statement was made in paragraph number 6 of the counter affidavit. Today, Mr. J. Hendrick, the learned counsel appearing learned government advocate, have placed before this court the Jamabandi of KP Patta number 53 of Dag number 420 of KP Patta number 53 of village Bonda under Moja Beltola. And shown before this court that a plot of land measuring 1 bigha 10 lesser is recorded in the name of the brother of the petitioner. In the backdrop of the above facts, this court have also heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner had submitted that in the land policy of 2019, the explanation to clause 2.2 defines the term family to consist of one or more of the following, namely husband, wife, minor children, and also includes a joint family. He further submits that the term joint family means a family of which the members are the descendants from a common ancestor and have a common mess, but excludes married daughters, married sons, and other children. The learned counsel for the petitioner therefore submits that though the petitioner and Sri Premjit Sharma may be sons of late Mohanlal Sharma, but they are married sons and have a separate mess, and as such, they cannot be construed to be a family within the meaning of the land policy of 2019. The learned counsel therefore submits that the petitioner is entitled to settlement as per the land policy of 2019, and more particularly in view of clause 14. Mr. J.C. Handik, the learned counsel appearing on behalf of the government, respondent state submits that as to whether the petitioner is a landless person, as well as to whether the petitioner would be entitled to a subject matter of consideration to be made by the Deputy Commissioner, provided the petitioner files applications seeking settlement. He submits that the petitioner does not have a right to claim settlement in respect to the land at Dag number 383 in view of the provisions of in view of Rule 15 of the settlement rules framed under the Assam Land and Revenue Regulations 1886, as well as clause 14.3 of the land policy of 2019. This court, upon hearing the learned counsels for the parties, and also having taken into consideration that the petitioner have already been evicted from Dag number 383, is of the opinion that there cannot be a direction issued by this court for the purpose of granting settlement in favor of the petitioner in respect of Dag number 383. However, if the petitioner files any application as per the land policy of 2019 and subject to fulfilling the criteria and the eligibility, an appropriate direction can be given to the respondent authorities to consider the application of the petitioner within a time-bound period. Accordingly, this court therefore grants the liberty to the petitioner to file a fresh application before the respondent authorities, before the Deputy Commissioner, na?
Deputy Commissioner.
Deputy Commissioner, Kamrup Metro, District Commissioner, Kamrup Metro, seeking settlement of the land in terms with the land policy of 2019 and also submit a copy of the certified copy of the instant order. Upon such application being filed, that the district commissioner shall duly take note of the provisions of clause 14 of the land policy of 2019. And if the petitioner is found eligible, the concerned authority shall duly consider the claim of the petitioner for settlement. This court, however, for the purpose of clarifications, observes that the land being in the name of land being recorded in the name of Sri Premjit Sharma shall not affect the rights of the petitioner to claim settlement in terms with the provisions of the land policy of 2019 and the settlement rules. The record so produced is returned. Shall be considered. The said exercise be completed. The said exercise, the said application. It is further observed that the said if such application is filed, the same be considered within a period of 1 year. 1 year.
The earlier his father was applied. Father already been expired. Let him the.
I'm not on that.
Correct.
No, 9.
9 lordship. The last occasion was directed to my lord. That submitted some inquiry report lordship. They thrown up a divisional commissioner. Divisional commissioner is not my lord. Lordship GAT can say whether this any inquiry has been made or not.
The last order make a division, my lord.
Yes, then what happened? There was a direction to conduct an inquiry.
Now, the divisional commissioner, has been.
Don't make that submission, because the earlier submission that was earlier made, and there was a direction passed by this court to the principal secretary to the government of Assam GAD.
I'm sorry, my lord, that no instruction has been received.
Who is appearing for the GAD? None appears for the GAD on call.
They have some separate.
I know.
Name notes.
Not there.
Let me inform you.
None appears on behalf of the GAD on call. Mr. J. Hendrick, the learned counsel appearing on behalf of the state, submits that the GAD department is represented by a set of standing counsels. However, none has appeared on behalf of the, but however, no standing counsels of the said GAD had appeared before this court. Accordingly, list the matter again on 4th of December 2023, on which date the registry is directed to indicate the name of in the cause list the name of the SC GAD.
Obliged.
Sir, order dated 26/7/23, my lord. In the dinner.
You have filed a memo, parties.
File.
Who is appearing for PWD?
He not will appear in this
Yes.
matter.
Why he has not appeared?
He is next in another court lawsuit.
What is your matter? Case about?
My lord, the respondents authority may acquired my land, my lord. Earlier occasions is 1 week 7 lessons.
Hmm.
And for that, my lord, compensation was paid and I have withdrawn. But the respondent authority, my lord, acquired 4 vega 1 kata 13 lisa more land, my lord. And I paid for compensation only that, my access to that land, my.
Yes, Mr. Nath. What is your instruction?
But I am awaiting the instruction. But I need 2 weeks time.
Huh?
I need 2 weeks time.
Why?
But on last occasion, we have been implemented, and
No, you were not impleted last occasion. You were impleted last occasion. Last occasion.
but I appeared.
You appeared
Yes, Lordship.
on 26/7/2023.
Yes, ma'am.
Thereafter, the matter came up on 28/8/2023.
But
The
possibly,
matter came up on 15/11/2023. We are today on
possibly I have missed.
the last to last.
I have already communicated. But some
They are not listening to you.
I have communicated. I am awaiting the instruction. Lord. Kindly give me some time. I'll get it.
When?
Well,
One has to be more clear on this. If the land has been acquired by the revenue, by the PWD, and he has been deprived of his land, if you don't take it, give him back his land. Because the last instruction is of 21st of July 2023, where initially a amount of 40 lakhs 13,250 was found for 1 biga 7 lessons of land. And that too, the petitioner was given, the petitioner did not receive. Have you received or not till now?
Receive.
You have received it. Good, at least. You now have the strength or the petrol for fighting.
Right.
Okay. Now, as regards the remaining amount, 1,14 lakhs 54,834 has been assessed and it has been submitted to the PWD. What is the PWD doing?
But I'll get the instruction.
Meaning the assessment has been being made in favor of the petitioner, mean as per the revenue authority, the land belongs to the petitioner. So, where is the land?
My lord,
What is the land being used for?
national highway, my lord.
Oh.
National 15.
National highway. You do one thing, put a toll booth. Yes, collect the money from there.
My lord,
You can't stop it. So you put a loan booth, they will give issue a notification because if they don't have the money. PPP.
Well, I'll get the instruction.
my lord,
Kindly give me
When?
some time. Well,
Because the estimate has to be approved
Yes.
by the PWD.
Yes.
When are you approving the estimate?
No,
That's all.
But I'll get the instruction in absence of the instructions. It is difficult on my part. But,
When?
Lordship, can you take up next week? I'll get.
my lord, I prayed for interim order in the first as motion stage because my lord, they are my lord working my lord my land without giving anything.
Understood.
My
You
lord.
want the money.
My
Possession has been taken.
yes, my lord.
So the interest will accrue on the basis of that.
My lord.
And has that, when was the 3G file? Who is appearing for the Sharia? You are there. Who is appearing for Kala? When was the 3G filed? 3G made. 3G with an additional was made when? Because he has to file an objection. You have to, if you have any problem, you have to file an application.
Yes, sir.
Where's the 3G report? Where's the 3G report?
As per my instruction, Lordship, 3G was submitted before the
Now, have you made the 3G report?
Lordship, yes. 3G, new additional 3G, yes, Lordship.
Where is that?
No, not in the record, Lordship.
Then bring on record the
Plus.
3G.
Lordship.
If you have made the 3G or not, let us see.
Plus.
Okay. Mr. D. Nath appearing on, no, Mr. S. Dutta appearing on behalf of the, no, you can't do that. She can do. Ms. S. Bolwa appearing on behalf of the additional Deputy Commissioner. Revenue. Kala is additional Deputy Commissioner Revenue. Who is the competent authority? Is directed to ensure that the 3G report in 3G report, 3G, the report under section 3G1 of the National Highways Act 1956 in respect to the additional compensation of the amount of rupees, additional compensation in respect to the area of land in respect to the amount of rupees 1,14,54,834 be produced before this court on the next date. Mr. D. Nath appearing on behalf of the PWD submits that he would obtain necessary instructions within a period of within 1 week as to what steps the PWD department has taken subsequent to the estimate, subsequent to the submission of the 3A, 3D, and 3G with additional amount of rupees 1,14,54,834 to the Executive Engineer PWD Rongia NH Division for providing fund. List the matter again on 11th of December 2023.
Can we have an unusual intelligence of your question? Item number 18. If it is convenient to your lordship, can be on 19th of December. If it is convenient to your lordship.
What is the matter about?
Item number, the genesis goes back to 1998 when there was a writ petition against their section 343 notice of the GMC. I am for the respondent saying that recovery of possession and that 343 notice was given because construction permission was given to me. In front of that, there was a godown. So the 343 notice was challenged by him and stay was given. Eventually, it was vacated. A writ appeal was filed. An agreed upon order was passed by the writ appellate court that upfront I will give him 50,000 rupees. And when the building is constructed, I will give him 650 square feet of godown area. So the building was constructed in 1999. So 2000 I offered him after giving 50,000. Take this in the basement. Then he filed a contempt in 2000. 2005, eventually the contempt was closed, saying that there was no which floor you will be given, it is not done. You were given 650, you are not accepting it. So therefore, contempt was closed. The whole thing remains silent. 2014, a writ petition was filed that the erstwhile advocate, whoever, he failed in his duty and he has filed a complaint to the Bar Council of India, which eventually got to be dismissed. Therefore, he asked for 650 square feet at a rental of 2000, which was not the rental fixed by the writ appellate court, and said that it should be in the first floor, what he said in the contempt. So now, in the meantime, since he did not occupy, and the 12 years period went, and the section 14 advantage which he could have taken, I have also given it in rent because 650 I cannot. Now the so is the repetition before. I am for the
2014.
2014, we came in. Our main ground was that in the appellate court, an affidavit was filed by the respondent in clear terms saying that will be given a ground floor because the basement that was not reflected in the division bench's order. And that was the advantage they took. And our counsel, the earlier counsel, was not present on the day when the contempt was sought. If we would have referred to the affidavit filed by them, giving an assurance to the division bench, this problem would have not.
But what do you want in a repetition?
I wanted, it was an agreed order that I'll be getting a place of 650 as agreed upon by them and a amount of 50,000 that was paid. But the fact that they gave us in the basement, we refused. Because their affidavit in the miscase in the before the
Now,
division
wouldn't
bench
that
was
amount to reviewing an order which has been passed by this court?
the appellate order remains in force because in the meantime, the lawyer did not inform us for around about 10 years. And we got
Understood, but whatever
Then
may
I
be, there
immediately-
has been orders being passed by an authority, by the courts.
Yeah.
Those orders, if are not interfered with in the normal course of events, how can in a writ proceeding, a writ can be issued contrary to those orders?
No, because we could not have gone before the division bench because of we were not informed that the case was pending.
Understood, but then also, whatever may be, you need to either take the leave from the division bench and then approach and file a review. But you have not done. But how can a writ be issued for correction of something which has been passed in a judicial order?
But it was the court never went on merits. It said that it was an agreed order.
Understood, but then
Our
also there
case
is an
was
order.
implemented.
There is a judicial order. Can this judicial order be in any manner be touched by a writ?
But for the fault of the
Maybe.
lawyer,
So for that, you need to, don't you think that the review would have been the proper course? But how can a writ be issued? Look, this court will be exercising a writ saying that that order should not be taken in view of the fault of that particular person.
No,
But how can this court
yes,
do that?
because on record before the division bench, he had assured to an affidavit in clear terms that will provide.
Understood. So then wouldn't that be a case of review before the division bench?
But then at this stage, we may again seek the remedy. So with the review, there is no limitation. Okay, proceed.
I think that is the best
That will
way.
be the best.
You withdraw with the liberty
Yes,
to
with,
review.
liberty to.
Matter is that
My submission was
That will be better.
item number 19.
19.
18. I'm sorry, my lord, I have interrupted in between. This is many young lawyers are there. This should not be the practice of the court. Appellate court order is at page 57.
Pursuant to a dispute which culminated into an order passed on consensus by the division bench of this court on 38/1999 in writ appeal number 138/1999. it was observed that the respondent number 2 herein, who was the respondent number 3 in the said appeal proceedings, shall pay a lump sum amount of rupees 50,000 to the petitioner who was the appellant therein within a period of 2 months from that date. And also out of the construction which was coming up, the respondent number 3 therein shall rent out a constructed area measuring 650 square feet, for which the petitioner shall pay a sum of rupees 2,500 per month as rent per month. The learned counsel for the petitioner, Mr. Dikeda, submits that the order which was passed by the division bench dated 38/2099 was passed without taking into consideration the affidavit which was on record. And it was on account of the fault of the counsel who was then appearing on behalf of the petitioner that the said affidavit was not pointed out. Be that as it may, by the instant writ petition, the petitioner seeks a change to clause number 2 of the order dated 39/8/2099 to the effect that the respondent number 2 herein, who was the respondent number 3 in the said writ appeal proceedings before, directed to provide the petitioner with a constructed area measuring 650 square feet on a monthly rent of rupees 2,000 per month in the completed floor building known as Jagdishwar Palace, located at Fancy Bazaar, Guwahati, in the ground floor of the said building. In terms with the assurance given by the respondent number 2 in herein in Miss Case number 1403/99 in WPC number 6384/99, based upon which the order dated 38/99 was passed by the division bench of this court in writ appeal number 138/99. It is the opinion of this court that the issuance of a writ which have been sought for would be against an order which has been passed by the division bench of this court, which cannot be done. The learned counsel for the petitioner submits that the petitioner, on advice, have been bona fidely and diligently pursuing the instant litigation. And as such, liberty may be given to the petitioner to approach to seek review of the order dated 38/2099, passed in writ appeal number 138/1999. In that view of the matter, this court, taking into account the above, as the writ which has been sought for cannot be issued by this court, and taking into account the submissions so made by the petitioner that he would be permitted to withdraw the instant writ petition with the liberty to approach the division bench, the instant writ petition stands closed, Pusto. The petitioner would be at liberty to approach the division bench of this court, if so advised, provided the same is within the permissible under law.
I love it.
Yes, Mr. Vanik.
I'm standing in as a legal aid counsel.
Huh?
I'm standing as a legal aid counsel.
Legal aid counsel and asking for 532 crores.
This was filed earlier, subsequent to change of counsel again.
So in fact, we have also raised an objection on 4/8/23 in the order lordship has noted.
Yes.
Under Article 39A, whether he is entitled to get the legal aid or not. To that effect, my lord, raising the preliminary objection, we are required to file an affidavit. I'm told that
The concerned department was directed to pursue the matter and there's a note to it. It says,
What are you asking for?
basically, the lordship takes a page 148.
What is the relief you are seeking for?
That's page 39. This is the implementation and taking appropriate action to recommendation with 9920 to grant the adequate compensation and direct the respondent to complete the payment investigation. And for direction to Deputy Commissioner to release the statutory compensation in terms of notification. So it's 148, my lord takes up for a moment. This is the hearing, although final order passed on a complaint lodged by me. If I read it, the facts would be clear. One paragraph basic.
How did the court come to this 532 crores?
Actually, what happened, he was pursuing a course of a commercial project, the license flying club, and there was some.
The amount is qualified as per that act?
No, not quantified. I've read the petition before. It was drafted earlier, someone else. What happened is that there was two amounts that were released by the government in some cases. Now there was a delay of release the amount. Now this entitled whatever benefits you would have got from that commercial pilot license, otherwise got entirely delayed and frustrated. So the computation was made over the loss as what could have been treated out there. But nevertheless, under the order at page 148, it says that it's the first paragraph would be sufficient for that. Please follow it up. 148.
Yep.
Yes.
May I? The matter was listed for hearing on 9/9/2022 at 11 a.m. before Vice Chairman, National Commission for Scheduled Caste so-and-so in his chamber on the 5th floor, Lok Nayak Bhavan, so-and-so. The petitioner informed the commission that he is the first scheduled caste candidate in the entire Northeast India, beneficiary of centrally sponsored scheme of post-matric scholarship for scheduled caste students for undergoing commercial pilot license course. One middleman lodged a false complaint against the authenticity of the scheduled caste status and intentionally delayed the payment of the scholarship, thus preventing timely completion of the ongoing pilot training course. Further, he filed FIR against the official who involved, but no charge sheet has been filed by the IO with the stipulated period of 60 days from the date of registration of the FIR under the POA. The authority informed the commission that the investigation officer submitted prayer before the Honorable Court for adding section so-and-so of the SC/ST Prevention of Atrocities Act 89. Accordingly, the Honorable Court passed an order to add the section. The case is re-endorsed by the Deputy Commissioner of Police, East Police, District Guwahati by so-and-so, dated so-and-so, but CD of the case is not yet to be received. After hearing both the parties in detail, it is found by the Commission that the additional secretaries who appeared in the hearing have delayed the matter intentionally, which could have been settled at their end. The purpose of the post-matric scholarship for scheduled caste students was totally defeated due to the negligence of the concerned officers, which has laid undue hardship to the petitioner, and he had to sell his land and mortgage his property to pursue his studies. The Commission recommends the concerned police department recommends the concerned police department to reinvestigate and arrest the person who made the false complaint against the petitioner, which eventually led to delay of the process of scholarship to the petitioner. An appropriate action may be taken against WPT and BC department to ordered to reinvestigate the caste certificate of the petitioner. Due to this, the petitioner incurred huge loss. The commission recommends that the petitioner be given compensation accordingly. Action taken report ATR is submitted by the commission within 21 days from the date of issuance of the minutes. So this having not been done, there's a notification under which the computation is done. That's at page 155. 155.
Yes.
So this is by the Ministry of Social Justice and Empowerment, Department of Social Justice Empowerment notification, 14th of April 16. This gives the headings. It starts from 159 onwards, the norms for relief amount. How and whom and what situation is to be given. We are claiming under serial numbers 2, 16, 17, 40, and 41.
How to? Dumping?
No, not this.
Huh?
Not 16. It got typed there. 16.
False, malicious, or vexatious legal proceeding.
2.
85,000 to the victim or reimbursement of actual legal expenses and damages, which is less. Payment to be made as follows: 25% at first information report stage, 50% when the charge sheet is sent to the court, 25% when the accused are convicted by the law. Okay, then
17.
Giving false and frivolous information. You'll be claiming from whom? From the person who has made that false thing.
This is
How are you asking from the state?
what we are on is the order at page 148. It says, due to this, the petitioner incurred huge loss. The commission recommends that the petitioner may be given compensation accordingly.
Understood. By whom?
In terms of the notification, the compensation is to given to the candidate. The person
Who will pay this compensation?
that is for the authorities to ensure. How do I get the compensation?
The
May I-
authorities
may I
will
read
ensure.
155?
Normal. Let us see annexure 1. Where is it mentioned in the rules?
155.
Where is it mentioned as regards compensation? Where is the actual rules?
Which starts at
This
page
is an
155.
amended one. This is only an amended one. It is in the
I understand.
amended
I
form.
understand.
It is not the actual one.
Actual rules. But the computation of so and so crores were on the thing that what the loss he had suffered for not being employed after having the qualification at that point of time.
These are questions of facts. How can this court decide?
We understand, but so far as the entitlement to the compensation is there, that no one is moving ahead, and in these circumstances feeling aggrieved is that. Of course, on the count of whether being scheduled caste alone, he could have claimed the legal aid. That was also a question which dropped that in the last occasion.
That is
They are
that
speaking
is
on that.
that is touching on
They are speaking.
Mr. Bonik's locus,
He was given the brief by the officer.
not on the basis of the material.
Anyway.
But whatever may be, what type of petitions are these? If he wants to claim any amount, look, go before the authorities. Has he approached the authorities for any amount?
But we'll come back to the main route.
No, has he asked for the because he is asking for this compensation. He's asking for implementation of this order. But whether there was a direction or does that rule stipulate that the payment has to be made by the state authorities or it is by the accused? Because if, just for example, a false and frivolous complaint is made by A against a person who is a scheduled caste or a scheduled tribe, then obviously it is that person A who shall be responsible. How can you bring the state out here? And why he knows very well that who made the complaint?
Yes.
Then why he has not been made a party?
So far as these the proceedings are
And
concerned,
further to that, if he is made a party, then it will be the thing that this court would be directing. Now, is there out here any rules that saying as regards a delay in completing the investigation?
no. Delaying it, that part is
How
not
do you
but so far as
how do you ask 532 crores from the state?
for the 532 crores, I'm on the statutory compensation which is there. Of course, it has been pleaded. has been pleaded, and it has been taken into account that non-engagement at that point of time would have led to so and so.
But which court appointed you as a legal maid?
I was not there. This was not even drafted by me,
No, who has asked you to become a legal aid now?
by the authorities,
Which authority?
but the concerned department.
The legally service,
Service.
legally service of the
By?
Earlier, some other council was
No, by whom?
the legal services.
Now, how they can do so in respect to this?
Earlier, Anuradha was there, Anuradha Gayan was there as a legal aid counsel. Subsequently,
Miss A. Gayan was appearing.
initially she was appearing in the.
Then
midway, there was a change of the council.
Then what happened?
Nothing, I just walked in and took up the paper.
You. What is your authority letter? Has he issued a signed a wakalatnama to you?
The officials issued a letter to me. The officials issued a letter to me.
How can the office issue a letter to you?
Because we are under the panel.
Unnecessary.
So I was engaged.
Who is the office? Legal aid services?
This is-
Yes.
They had raised the question on whether the person could even get the legal aid.
Secretary, Guwahati High Court Legal Services. Who is the secretary? Has he approached him and
Yes.
this authority?
Yes, there are papers below on the file. I've seen after the query by this honorable court, the concerned authorities have given a note.
Then in that case, why any person who belongs to the scheduled caste or scheduled tribe should have a lawyer?
I have nothing to say. Mr.
No, I'm
I
asking you.
understand. Nothing to
So, that
If
is,
that be so, they will be providing the best of the counsel. Mr. Bonik is there.
I can
no
say-
SC people will come and engage lawyer.
They did not.
They'll go to,
They'll get Mr. Bonik.
in fact, Malad, Article 39, under Article 39A, that has to be followed. Because of economic deprivation, one should not Malad, be deprived of the legal remedy.
The
That is the
No, let us not go into all these
Malad.
things. Why should
Malad,
we go into
here-
trivial matter?
here-
But the fact that why should this court direct payment of compensation to the state authorities when it is the fault of somebody else and when that somebody else is not there? A person makes a vexatious complaint against a person who belongs to the SC or ST community, that person would be liable. And if he is liable, you go before the civil
I
court.
would like to place an additional affidavit detailing the factual background of this, because pursuant to that, any subsequent developments have taken place, and you place them on record. Regardless of that, they may also point out as to in what scheme they make the payment, because the rules are
Who has
amended
made the payment?
under the rules which have annexed at 155. I see there's amended. The amended rules are version there. I'll get the correct set of rules, and then we can go ahead with it.
Mr. Banik, this is a case which if I was sitting on the first day, I would not have issued notice. So I would not trouble them. First, you have to satisfy me.
No, so far as that part is concerned,
No, first you have to satisfy me. Why on earth should this court pass any direction to the state authorities for payment of compensation, that too in respect to a complaint which is vexatiously made by somebody else?
When
And-
even on that, when I had gone to the writ petition on the first day, they
And
don't
that too
keep in
asking
mind
for
that person
factor.
is not even arrayed as a party. So possibly the arraying of party needs to be done.
Hmm?
I've checked up, my lord, so far as the writ petition is concerned in the cost item. It came later on to me. Gentlemen concerned who had launched the complaint after we made a party hit, please. So that correction needs to be done by way of an interlocutory application. Thereafter, my lord.
I'm glad you. And he's a pilot, having a commercial license. Well, what is he applying with?
Not on job. He's not on job.
No, but he has a commercial license.
License is one thing and the job is another.
That is different, but he has a license.
That for that very
And
thing.
get it, you know how
Yes,
much is the expenses
got the
for
scholarship
getting
for that.
not only
My lord, he got the scholarship for
commercial pilot training, which is not less than minimum is 35 lakhs, and if you go to states, it will be around 75, 1 crore.
It was under a scheme, but was delayed in the disbursal of the amount, leading to delay in the completion of the course, leading to consequences.
How much was the delay?
40 months by the last one.
So
The courses have the time span and limits, and therefore the entire thing problem. It is in background, and only for the fact that this complaint was there in between. Eventually,
we dismiss it with the cost of 2 lakhs.
I think
No, we dismiss it with the cost of 2 lakhs
but so
for
far as
unnecessarily
but so far as the petitioner is concerned,
for filing this voluminous petition unnecessarily, for which we impose a cost of 2 lakhs.
Well, I leave it to your lordship.
And ask the legal services authority to pay the said amount
But so far,
to the registry of this court
so far as the person is
for
concerned,
engaging Mr. Bonik, and that payment be given to you.
kill with that.
That is the only win-win for
But
both.
the person is concerned. I may have a word with him, Mithun. If you
No, this type of matters
he
shouldn't
might-
come before this
in this
court.
circumstance, he might not like to press the petition. Once I convey him correctly, take up tomorrow, day after tomorrow.
No,
I leave
we'll
it.
have it there later.
Now, in this circumstances, which a problem,
Anyways, I'm not here for the next 15, 16 days. So let this matter go before any other bench who may be more considerate in this type of matters. Leave the matter before any other bench.
Obliged, Doctor.
Item 12.
He was draw of lots, he was selected. In the draw of lots, he was selected as the retail outlet dealership. Now the question is whether he's a member, nominated member of the Cooperative Council, and whether he is an employee. So therefore, the nominated member of a council is an employee, because they, after this election and all, they say you are not nominated member unless you resign from that post. So you will not be given the deal. So on the last occasion, your lordship directed 9/10/2023 order your lordship will conduct. So the court wanted to know what kind of duties you function as a nominated member. So 9/10/23 order your lordship conduct, and accordingly we have filed affidavit showing my duty is very limited. I can devote time for looking into the dealer. On page 38, that is the condition. They say we have.
What is, let us see what is the condition.
That is what I'm saying.
Where is the condition?
Page
Clause
38. Clause 6.
A person selected for
You will not
the
be eligible
dealership
for
shall be
taking up any
paying
employment.
attention towards day-to-day working of the dealership, personally meaning that he will not be eligible by separate. Now what happened? You are challenging this clause. Are you challenging this clause?
Yes, because of this, my lord, I am saying, my lord, I am not employed. I am not an employee.
Are you receiving anything?
No, now I am not receiving anything of.
You resign. Where you are keeping it?
And what they say, my lord, their person is page 96.
Understood, but you want to resign if you are not getting any benefit.
No, it is nominated by the government. There are political ambitions are there. Yes,
So,
nominated by the
if you have
government.
political ambitions, then what will happen to the dealership?
No, leadership, my lord, they are, because they have stated my affidavit, your lordship will kindly see page 96. What they say, you resign. Any other employment or nor will draw any salary. And if I am already employed, I will resign from the employment and then produce proof of acceptance of resignation by my employer before the acceptance of the letter of appointment. So, my lord, a nominated member is not an employee. For that matter, your lordship will kindly see this 2019-11 STP, MP, MLA, my lord, whether they are employees or not, this question came up. And the court answered this 2019, Ashwini Kumar Upadhyay case.
Yes, where
Paragraph 1(4).
we filed an affidavit, additional
Yes,
affidavit.
additional affidavit we have filed. We have shown what kind of work we do. And the council has also filed an employee affidavit saying that I'm not their employee. And in our additional affidavit, we have said that in another place, they have given it to another member of the council. He is not nominated, but he is truly elected member of the council. That affidavit, your lordship will kindly see, my lord. Page 128, paragraph 4. May I just read it? Up to the last 10. Not been entrusted, assigned with any committee, commission of the Karbi Anglong Autonomous Council. This regarded the deponent respectively states that the Deputy Secretary to the Karbi Anglong Autonomous Council by letter dated 13/10/23 informed the deponent that he has attended only 4 days in the Karbi Anglong Autonomous Council session, and the deponent has not been entrusted with any commission, committee of Karbi Anglong Autonomous Council. Deponent further respectively states that he attended hardly 1 to 2 hours as and when the session of Karbi Anglong Autonomous Council was held as reflected in the letter dated 13/10/23, and there is no other involvement of the deponent with the council, and he is not an employee of the Karbi Anglong Autonomous Council. Deponent also respectfully states, to the best of the deponent's knowledge, the respondent Indian Oil Corporation Limited by letter of award dated 25/22 offered a retail outlet dealership to Sri Madhurya Dhekial Phukon for the location Bokajan to Dimapur, so and so in district Karbi Anglong, who is also an elected member of the Karbi Anglong Autonomous Council. So therefore, on page 134, this is the time we are required to spend as a nominated member of the council.
These are questions of facts as to whether you have, for the time being, you have only visited 4 hours or 4 times out there. It doesn't mean that at a later occasion you are not going to do that.
No, by an order dated 9/10/23 to show the duties of the member of the council.
Understood.
That's
But the duty
So
is
according-
there that you are to be present in the session,
But it is not.
but you are not doing it. It's the difference.
No, my lord, in
Kindly read the paragraph number 4 of your additional affidavit.
Yes.
That being a nominated member, the duties and functions of the deponent is only to ask questions in the session of the council if so required.
Yes.
Further, the deponent has not been entrusted assigned with any committee, commission of the Karbi Anglong Autonomous Council,
Yes.
meaning thereby he can be. Secondly,
But
in this regard, the deponent expects that the deputy secretary so-and-so by a letter informed the deponent that he has attended only 4 days in Karbi Anglong session, and deponent has not even been entrusted with any committee so-and-so. The deponent further respects that he had attended only 1 to 2 hours as when the session of here. What is this nominated here? Let us see.
Yes.
Yes. Let us see the Karbi Anglong this thing on the basis of which these members work.
members nominated, that is that rule you got. Karbi Anglong Autonomous Council. Karbi Anglong has filed an affidavit.
Because these
They
are
said
questions of
But
today you may, tomorrow after getting the dealership you may be a full time out there. You may be.
But they are saying, my lord, Karbi Anglong has filed an affidavit saying I am not an employee. I'm
Understood,
selected
nay,
only
but is it the thing that a nominated member cannot be given a commission or an appointment in the committee?
that I will have to accept whatever they give me.
No,
I
no.
can refuse.
Are you saying that you are not going to accept?
Yes, I can say
That you have not stated anywhere.
if it is necessary, I can. do it.
You have to say that I am not going to attend
Yes.
any of the sessions.
No, they're not that. my lord. They
Tell
said
that.
so.
No,
They said no.
why should you? Why you say that I am not going to attend any of the sessions? I am not going to participate in any of these things because you on your affidavit say, then look here, I have never been out there. I've only only for 1 or 2 hours total.
This is the requirement as per the. my lord,
So show me that rules and what is the requirement of a nominated member? What you have done, it is a different thing.
Nominated members are appointed.
Because tomorrow, after getting this, you may very well say, then look here, and now I can go
Where to go?
to the Karbi Anglong Autonomous Council, being happy with a member.
Council, a nominated council of our council has got very little role to play in the functioning of the Karbi. Very little role. They are political, my lord, politically.
So that will be on the basis, that would be on the basis of the rules.
On the basis of the, because on the basis of the rules, my lord, we are nominated.
Understood. What is the role of a nominated member? We are not concerned what you have done.
Sixth of the sixth schedule to the constitution of the. I think there is a provision for.
No, I think they will have a rule.
There is a Contempt of Autonomous Council.
Mr. Chaudhary, have you looked into those rules?
The rules we have.
Because the rules will categorically show what is the functions. Because the rules have been made out there, that what they are going to do, how they will function, because it is a parliament. It is as if it is like a parliament, and he's like a MP, he's a nominated MP.
Yes. Your lordship will kindly see, they have already given dealership to one of the elected members. They have already given dealers. And
So for that is concerned, my lord, that has come in the affidavit in reply, and thereafter, my lord, we have intimated the IOC is taking up the matter because they were not in the know that that person is a member of the, my lord. It was my lord concealed.
Very well.
Now they will take the action, my lord. It's not that, my lord, because he was given. That was given, my lord, because it was not known that he is a member. So they will take action against that. That will not give this petitioner any right. And the rules are, my lord, mentioned in the notification.
What kind of role do you have?
Rules are mentioned in the, my lord, notification. Assam Autonomous District Constitution of District Council Rules 1951. That, my lord, I do not have.
That will show what is the role of a member.
True.
And whether a nominated member or not.
Now, my
Because
lord,
first of all, my lord, your lordship will have to give a decision on the matter whether he is an employee. Karbi Anglong Autonomous Council has filed an affidavit, he is not an employee. Tomorrow his nomination goes, or he is not a member of the council. He will not get anything. He doesn't get any benefit of an employee. This is what, my lord, MP and
No. They are not on the basis of being an employee. Their basic idea is, if you are in employment of somebody, something else, then there will be attention being given out there.
employment.
That is the basic reason behind.
I am not in the employment of the, my lord, Karbi Anglong Autonomous Council.
No,
I am
if you
a
are,
nominated member, and I am required to discharge some function. That because, my lord, what has happened in this case? I got a land in Diffu town. They have given an advertisement. So accordingly, the land they found it suitable. So in a draw of lots, my lord, I was elected. It is not that they have given some political favor or any other favor. Because of the land, my lord, the availability of the petitioner, he has given the name, he has applied for it, and he was selected. Now they are saying you are a nominated member. So therefore, nomination came later on. It is in the month of July 2022. Application was filed in the year 2018. Subsequently, I was nominated by the government. It's an honor by the government. My lordship knows. Therefore, my lord, he is not an employee in any manner, and it doesn't mean that I cannot look into the devote my time for the purpose of looking into the dealers. And your lordship knows, my lord, dealerships are always, my lord, looked into by a manager or any other person who will be appointed by the, my lord.
but the rationale why they don't want anybody is that they want that the person should be given 24/7 interest.
24/7, my lord, nobody can. I'll even if any person, my lord, unemployed person is appointed, he will have to appoint a manager, 2-3 managers. 24/7, my lord, nobody will sit in the. Many persons are running dealership or any other business. A person having a dealership runs also other business. Your lordship knows this is a, my lord, matter known to your lordship, my lord, that if I have a dealership, I can have a business of any shop or any other contract. There is no, my lord, power for that. That I will not have a contract. You cannot have any employment. This is what this Karbi Anglong nomination member is not a member, not an employee. Therefore, I was just looking into trying to take a lordship. So at least, my lord, paragraph 15 of the 2019 11 SCC, it doesn't. It says what is an employer. Employer-employee relationship is not. And my nominated member as a council member, it is not 24 into 7. It is 30 member. The session comes up, I am required to attend that.
Let us see the rules of Karbi Anglong.
I can show it, my lord, if it is there. The 51 rule is there. It's just a nomination. There is a provision for appointing nominated members.
What is the difference between a nominated and a elected?
Elected members are my lord, persons elected.
That I know, Mr. I am only asking what is the role different between a nominated member and an elected member?
That difference your lordship could not find it in the.
So they are equated in the same status.
More or less, my lord, they are nominated, but they are not entitled to get entitled to vote. They are not entitled to vote at the time of, my lord, any, my lord, removal of CM or no confidence vote. They are not. Your lordship knows recently also that they did. He is a nominated member by the government, my lord. Your lordship, in this case, your lordship will see, my lord, supposing I get dealership. I am not an employee, but I can do business. Any other business I can play so far for, and I will do, my lord. If I am successful in this dealership, I will definitely do with my lord. People is there, my lord. Anybody will do business, any opportunity they get. Here, the question is, my lord, whether I am an employee. I am not an employee. This is what MLA MP case, my lord, at least in paragraph 15.
I've read.
Paragraph 15, it says, my lord, I am not an employee for any matter. Now the second question comes is devotion. Whatever requirement time is, if the time is required, whatever time is required, I am required to give, I will have to give. I have no option, I will have to give that time.
And as per the tender condition,
yes,
there will be certain obligations which are there.
yeah, those I will have to fulfill.
And if you don't fulfill, obviously actions can be taken.
They can take action. It is not that I am barred from appointing any manager. I am barred from appointing any employee. Supposing, my lord, if after taking the dealership I fall sick, what happens? I cannot come, my lord. I am suffering from cancer. For whatever reasons, 1 year I am not. In case I know one of the case, my lord, where 1 year he was not there, subsequently he died. What happens? His dealership was run by somebody else. Now his widow, wife, the purpose of this act is, yes, employee cannot get. I am not an employee. Today I am there, tomorrow government may say, please get out. Mr. Das will go, the nominee. I can be removed anytime. Not an elected member. Elected member has a right to be there for 5 years. I do not have any right.
So that is what I wanted to see.
No, nominated member, my lord, this is a function, my lord, descended at Supreme Court judgment.
Understood. There
Yeah,
are
I'll
many
try
things,
to-
but I
I'll try
think
to
we
convince
have
you.
a rules for that.
Rule doesn't, my lord, distinguish between elected members.
Then also one has to look into what is the rule
Yes,
which
yes.
say, what is the real, then only this court can
Only
deliver a
what I
judgment.
remember, my lord, under the provisions of that 62 to the Constitution of India, communist seats will be elected, communist seats will be.
Understood, but what is the role? What is the role of the AI? How can he be removed and all these things will be there in those rules?
Nominated members can be removed by the government.
Should
They
I
have-
say
they
that
do
Mr.
not have any
Bidida
right.
submits, not even without seeing the rule?
Well, I'll bring it. Doctor will give me Monday. I'll see. I'll provide the rule.
Let's be day after, my lord. Let's be day after.
Yes.
Huh?
Day after tomorrow, my lord, because from first Monday I will not be here for.
I am also not there. Day after tomorrow, not possible. This matter will go before any other court. Because day after I'm leaving, then I will be back after 15.
Let it be after 15.
If the matter went.
Yeah.
No, not before.
Any day before any other.
Any day after
Wherever.
15.
The day after tomorrow, it will be very difficult for me. Because you see, if
I'll
I'm
bring
not
the
there
rules
for
back.
15 days, I have to sign so many orders. And
I'll bring the rules. And there are lots of the whole fact set in place. No,
yes, I won't keep it as CAB, I'll dictate it.
Yes.
So while dictating
Not
it, then I don't sign the order for 15 days. Tomorrow you will say, "Ah, what type of judge this is?
will
Not
not
signing
say
the order for 15 days.
we will not say anything. There are lots will decide.
Let the matter come up on first, second, fifth.
No, let it be after 10th, my lord. I'll be
After
out of
10th.
station.
Okay, let's have it on 19th of December.
Lovely.
Your lordship may mention that to produce the rules appointing.
No, we'll produce it. We'll produce it.
You have the rule.
Because different court,
Hmm.
different orders, different implications are there.
No, if
The
I'm
last-
taking, I'll be back on 18th.
Yes.
So I'll pick up on 19th if this matter. Because otherwise I don't require. It is only that thing. If I wanted to just see the rules. If I see the rules, if it is not there,
Rules of appointment of the
list the matter again on 19th for further consideration. Yes.
My lord, secretary of a, sorry, my lord, president of a Gaon Panchayat, my lord,
Hmm.
removed by a motion, my lord, of no confidence. My lord, the secretary, my lord, he being devoid of jurisdiction, he sent it to the Ansalik Panchayat on the 12th day, my lord. The mandate is 15-1, my lord. It has to be after 15 days, my lord, he gets the jurisdiction on that count.
Where is the notice?
Yes, my lord. Notice is, my lord, with all respect, my lord, notice is that page 19, my lord.
You received it when?
My lord,
When did you receive it?
I received it on 18th, my lord.
No, the secretary received it on 17.
Exactly.
You received it when?
But I received on, my lord, on 18th, my lord.
Where is it?
Page number 19, my lord.
What is that? Where is the sign?
My lord, sign is the, my lord, vernacular, my lord.
Hmm?
Page number 18, received, my lord, by the secretary, my lord.
That I've seen it. What about 19? And when was it sent?
My lord,
When was it sent? 33.
33, my lord. That is on the 12th day, my lord.
After the president received it. After the secretary received it. 13 days. 17,
My
the president, the secretary received, and 13 days thereafter
yes.
is 30.
My lord, had he sent it on 2-4, my lord, 12-4, my lord, then it would have been, my lord, 15 days.
2-4.
2-4, my lord. 2-4.
And
This is
then
the case.
that is the case.
Yeah, okay.
Have you got to stay?
My lord, no
Uh,
stay.
Then?
Yeah, my lord, there is an order, my lord, of this honorable court, my lord. They are operating, my lord. That is that, my lord, we call it order to create. They filed a, my lord, IA in this application, and the order which was passed was this, that
interim arrangement can be made till final disposal. That is a page 82 of their, my lord, affidavit in opposition. Property part 82, my lord. It begins from
Of page 82 of what?
affidavit in opposition, my lord, filed by respondent number 8216.
Annex E.
What is that?
Number 82.
However, it is made clear that whatever arrangement is made in this regard, the same shall be subject to the outcome of the requisition.
Exactly, my lord.
Yes, who is appearing?
My lord, I am appearing for private respondent, one
Yes.
number. Lordship,
I'm for the panchayat.
We'll hear the private respondent later on. First, let us hear Mr. N.K. Devnath. What do you have to say?
My lord, certain judgments have been cited.
No,
Yeah, pretty in
not see
opposition.
the judgment. Let us say, when did he receive it as per your records? You must have got the record.
Yes, my lord, I have.
When did you receive the requisition?
I received it on the 17th.
And when
second
did
week.
you send it
On the 18th.
to the Anchalik Panchayat?
30th. 30th.
How did you send?
Well, actually, the provision says that it is supposed to be sent if in case such a meeting is not convened within a period of 15 days from the date of receipt of
So, 15 days he has the time.
My lord, there are certain judgments passed by the division bench of the Honorable Court which says that this particular timing is not mandatory, it's directory. And the president having received the notice, my lord, did not show any intention of actually convening.
Show me that. Where is that? Which judgment?
Well, if my lord, we'll have a look at the affidavit of opposition rules have been cited, my lord. Really do, okay? Really. What you want to receive?
Yes. Which paragraph?
Well, Mumtaz, Prana, Lotker, and others.
Mumtaz jana question to decide to put Shruti mo napa to put.
Yes.
Para 24, man. May I read one?
Yes.
Let my lord on the judge.
Then
My lord, this judgment
This was referred, my lord, to a key judges.
Mushira Bibi versus State of Assam. Para 10, my lord. 10 and 18.
Anna,
Para 10 and 18.
Mosira Bibi.
Yes. No, this one, sorry, madam. Mostly we para 17, madam. 17 and 18.
This is a case of waiver.
Yes, ma'am.
Now, tell me, today, if we accept what it has been mentioned out there, a period of 15 days is given.
It is within 15 days.
He has to convene within 15 days, which means up till
Up till
15 days. And it also uses the word clear, 15 clear days.
sorry, madam, I haven't been able to notice that. It says
Wait,
that in case such a meeting is not done within a period of 15 days from the date of receipt of.
Anyways, 15 days. So can you take over his right and go ahead and the secretary can overturn that mandate of 15 days? Isn't that the right of the president? Yes. Mosira Bibi is a case where it says that I say that I'm not going to hold it. Meaning thereby, I have given up my right to hold it. And therefore, she can very well refer. But if it is a case where it is not so, can you say that?
Actually, in this case, perhaps this is the actual situation. My lord will have a look at the affidavit and reply filed by the petitioner. From there, it's very clear that they do not want a meeting to be.
Now, if the petitioner,
right from the beginning, he had.
no, it can be extended. Even this court is also of the agreement to the effect that if it is even 10 days or 5 days also it can be, provided the petitioner waives his right, saying that I am not going to hold it.
It's not there in
If
writing.
it is not there, can you say that the mandatory period of 15 days can be overtaken by the secretary, saying that, okay, let me send it? Because once it is sent to the Ansalik Panchayat, the president loses his right even to convene. Can the president thereafter convene?
My lord, can I make one?
Yes.
My lord, without going into this controversy, if their issue is regarding 15 days, let within 15 days from today, date be fixed, let them face the no contest. It's a democratic process, end of the day. Let there be floor test.
That's
Yes or no,
many
my-
judgments orders I have passed.
Yes,
Within 15 days,
from today.
he has the notice. So from today.
He cannot say that
But
he did not-
meanwhile, my lord, the stopgap arrangement, my lord, I have lost everything, my lord. Name, fame, everything, my lord. Because they sent it on the 12th day, as your lordship has said, my lord. It is nowhere on record that I did not intend to hold the meeting.
It's okay.
Yes, my lord.
You
15
have
days.
been given 15
But
days. from
meanwhile,
today.
my lord, I take charge. Meanwhile, my lord, and thereafter, if I lose, the law will take its own course.
Not taking charge. He'll face the floor test and thereafter, whatever is
Yeah,
ordered, he will.
What?
He will not be taking charge. He'll not.
How can he call? Tell me. If he doesn't take charge, how do you call?
There is no stay of this proceeding.
Whatever it may be, if I don't set aside that terminate or the cancellation, how can he call? Tell me, can he call as what the rules?
No, meeting can be called by your lordships can say fix a date.
Whatever may be, but he's not the president. It is for the statute mandates that it is the president who can call.
Exactly.
There is a president as of now.
My lord, to be honest, my lord, I have gone through the different judgments of this honorable court, including the full bench. My lord, the preponderance of judicial view seems to be, my lord, it's not mandatory. Especially on this one, there's a clear-cut two division bench and supported by the full bench. I was thinking, my lord, we can avoid this. My lord, there are so many orders passed by this honorable court. Status quo as on today be maintained and let there be meeting on the 15th day. Or all that, my lord, same and let the deputy commissioner or somebody hold the charge in this.
That is not the mandate of law.
Why the court can always make it.
No, it will go to the deputy commissioner subsequently.
Yes.
No,
yes.
what I'm saying. in
We
the
are at the
meantime-
stage of 15.
Or let the circle officer also can be given charge in this interregnum matter. Well, lordship's power under 226.
No,
is there.
you see, the interim order to the effect that there shall not be any major financial decisions
Ah.
or that will remain.
That
Yes,
can be.
yes.
But he should be the president.
Exactly.
Okay, my lord. No
Let
major
him-
policy decision,
No,
including
that he
Yes.
cannot do
Yes, yes.
anything for this
Yes.
period. Because unless he becomes the president, he cannot.
Absolutely.
Only thing is, my lord, lordship will fix a date.
Oh, yes.
15
When?
days from today.
When?
I think 1 तारीख. कितना है?
15 December.
13, 14, 15.
12th, my lord.
No, it can't be. It has to be 15
Or
days.
15 days.
12.
12. So I said beyond 15 days also it could be.
No, he can't.
Within 15 days.
He has to do it within 15 days. So what will be today?
Actually, my lord, when we say within 15 days, it is necessary one has to wait till 15 days. That is another aspect, my lord.
No. I can give him the liberty to hold it within 15 days.
Yes.
That is on or before that.
Yes.
So he has to hold it.
Yes.
If he
Malaki,
does
otherwise-
not, then the authority will take its course.
Yes.
Yes.
So today is what?
If it is not held, it will be construed that he declined to hold the meeting, then other sections.
Then
of the-
obviously, if he doesn't hold it within this, then you can very well proceed.
Within 15 days.
By 13 December.
Well, I think in an appropriate case, lordship will also will have to say what will be the position. Is it necessary that one has to wait till the 15th day?
No,
If
the-
otherwise he is aware of that notice. I'm saying, my lord, maybe in an
No, the
appropriate.
power has been, he has been given a power. Because you see, one has to also take note of that he is not a nominated member. He is an elected.
Is elected and
Isn't it? So he
and
being
in
an
regard to
elected
that, my lord, the procedural safeguard assumes much importance.
important. So that
The
is why.
secretary gets the power of jurisdiction only on the 15th day. Thereafter 3 days in between. Within 3 days, he is to send it to the answer.
So we will have it on 13th,
13th.
but on or before 13th.
On or before.
You have
Meanwhile, I assume sir without power, my lord, finance.
the order I have set aside,
My lord.
and however, no financial
Yes,
power.
yes, my lord. Very much. Very much.
Okay, let me pass the order in your presence.
My lord, what matter is going on?
Who is sitting?
Order number 6.
An academic, another, my lord, that mandatory part, my lord, that full bench, my lord, it has categorically said, my lord, in all totality, my lord, with all respect, my lord, the mandate of 15, my lord, inclusive of the later part, my lord. It is not directory. The Farhana, sorry, my lord, Mumtaz has not said that. It is cleared in Farhana. There's a wrong proposition, and several single benches, my lord, thereafter have categorically said.
I also held 15 days.
Yes, my lord. And
Mm.
the 15 one is mandatory.
But then, my lord, if it is communicated by the president before the 15th day that he is not going to convene the meeting, then is the secretary to wait, my lord, till the 15th day? That is also an issue, my lord.
He can. If on the 12th day also, if he says that I'm not going to do it,
He can
then
send it.
the secretary can send it.
Exactly, man. Perhaps in this matter that has happened. Because if my lord will have a look at the affidavit reply also, it clearly is evident, my lord, that the president never had an intention of holding a meeting.
How come?
In fact, that is why he is also fighting against the resolution.
No,
I
therefore, whatever may be, for that, if you want, we can very well decide this aspect on some other day.
Some other. But this is also one fact, my lord, that it
No,
cannot
you
be
want that,
mandatory,
we
my
can
lord,
go
that
into
it
that.
cannot-
aspect.
On record that I refused. My right was curtailed because it was sent on the 12th day. In between those 3 days, what I could have done, can you read my mind, my lord? What you're saying is preposterous, my
That is
lord.
one provision, like the other provision could be that the president never had an intention of holding.
No, no,
a
how
meeting,
come he decided?
and that was
Is in the-
communicated,
is in the-
perhaps
how-
verbally or by his actions.
How is he in the know of things?
Then
my
the
lord?
secretary took this action.
I mean, Mr. Devnath, if somebody just outside out there also says many things, but if he doesn't come out here and say, makes no meaning. It means this, what is there on record.
My lord.
The instant petition has been filed by the petitioner challenging the resolution dated 29/5/2023, whereby the petitioner was removed from the post of the president of Rampur Satra Gaon Panchayat and has that been approved?
My lord.
Has it been approved by the DC?
No, to our knowledge, we don't know.
Huh?
Give it be knowing.
Then how is it come into effect?
It was communicated, my lord. There is a communication. by
Communication is different. What is approved? Because the DC has to approve.
Yes. 750.
I've seen many cases where writs have been filed because the DC is not approving.
Absolutely, man. In case of
There is a communication made by the
Executive
office of
officer.
the deputy commissioner, but as far as approval part, that document is not. Because these documents have come from the office of the CEO, my lord.
Huh? Has it been approved?
I don't have any document in that regard.
Then on what basis they are functioning?
Well, perhaps that has taken place, my lord. Others, he would-
Although on the basis of the resolution, he becomes out.
that needs
But that has to be approved.
Yes.
But that has not happened.
That perhaps has happened, my lord. But as far as the documents are concerned, I don't have a document. Substantiated. So these documents have come to me from the office of the block development officer, Bata Development Block Noga.
Final for the meeting dated so and so.
Until
Challenge the resolution dated 29/5/2023, thereby removing the petitioner from the post of the president of Rampur Khatra Gaon Panchayat, as well as also the impugned communication dated 29/5/2023 issued by the executive officer Botodroba Anchalik Panchayat to the deputy commissioner Nagaon. The specific case of the petitioner herein is that the requisition was submitted by
eight ward members.
8 ward members of Rampur Khatra Gaon Panchayat to the secretary Rampur Khatra Gaon Panchayat, which was received by the secretary Rampur Khatra Gaon Panchayat on 17/3/2023. Thereupon, on 18/3/2023, the said notice regarding no confidence against the petitioner was served upon the petitioner. Full stop. The petitioner's further case is that without waiting for the mandatory period of 15 days, the secretary referred the matter by the communication dated 30/3/2023 to the President Botodroba Anchalik Panchayat. Thereupon, it is the further case of the petitioner that 10 ward members joined together to file a writ petition before this court, which was registered and numbered as WPC number 2363/2023, whereby this court issued notice and further observed that the pendency of the writ petition shall not be a bar for the respondent authorities to proceed with the matter as regards convening of the special meeting to discuss the motion of no confidence as per the provisions of the Assam Panchayat Act 1994. Thereupon, the petitioner further states that on 29/5/2023, the special meeting was convened at 11 a.m., showing that the said meeting was being conveyed as per the direction of this court. Nine members voted against the petitioner, and on the basis of which the president of the Batodhrabat Anchalik Panchayat declared the meeting of no confidence was over On the same day, the executive officer of the Batodhrabat Anchalik Panchayat issued a communication to the Deputy Commissioner Nagaon submitting the minutes of the no confidence meeting. It is, however, not known what steps have been taken thereupon by the Deputy Commissioner Nagaon. The petitioner, on coming to learn about the same, approached this court by filing the present writ petition. This court, by an order dated 5/6/2023, issued notice, and in the meantime, it was directed that the Gaon Panchayat authorities shall not take any major decision as regards the financial affairs of the Gaon Panchayat other than the decision as regards its day-to-day affairs. The record reveals that the private respondents, that is the respondent number 8 to 16, have filed their affidavit in opposition. Wherein was duly admitted that on 18/3/2023, the President approval was sought for convening the meeting of the no confidence. It was also mentioned that the President of the Gaon Panchayat did not, President of the then Gaon Panchayat, the then President of the Gaon Panchayat, that is the petitioner, did not accord approval for the same, And as such, the secretary forwarded the matter on 30/3/2023 to the president of Batardraba Anchalik Panchayat for convening the meeting of no confidence. It was further mentioned that on the basis of the orders dated 8/5/2023 and 17/5/2023, passed in WPC number 2363/2023. The no confidence meeting was held on 29/5/2023, which was presided by the president of the Batardraba Anchalik Panchayat. And thereupon, a no confidence was passed against the president of against the petitioner by following the provisions of section 15 and 18(5) of the Assam Panchayat Act 1994. Further to that, in the said affidavit, various judgments have been referred to. Be it as it may, it is seen that on 9/11/2023, just 2-3 days before,
9/11.
the Chief Executive Officer, Nagaon Jilla Parishad, had, in pursuance to an order dated 18/10/2023 passed by this court in IA Civil 2790/2023, conferred powers upon one Musabir Hussain, the Vice President of Rampur Sotra Gaon Panchayat, to function as the President of the Rampur Sotra Gaon Panchayat, subject to final outcome of the writ petition, of the present writ petition. This is 3-2 of the present petition. I've heard the learned counsels appearing on behalf of the petitioners. Mr. B.K. Mohazad, the learned counsel appearing on behalf of the petitioner, submits that the secretary of the Gaon Panchayat could not have submitted that the action of the secretary of the Gaon Panchayat to refer the matter to the Anchalik Panchayat on 30/3/2023 was in clear contravention to section 15 of the Assam Panchayat Act 1994, which mandates that the president be given 15 days period for convening the meeting. He submits that admittedly on 18/3/2023, the requisition notice was served upon the petitioner, and as such, till 2nd of April 2023, the secretary could not have taken such an action. Mr. K. Chaudhary, the learned senior counsel appearing on behalf of the respondents, private respondents, submits that as to whether the rule 15, section 15 of the Assam Panchayat Act 1994 is mandatory or directory is is a question which could require a detailed discussion, a detailed analysis. But however, he submits that the private respondents are not adverse to giving the petitioner an opportunity to hold the meeting within a period of 15 days from today, that is on or before 13th of December 2023. He submits that if the petitioner fails to do so, then the law should take its course as per the stipulations contained in the provisions of the Act of 1994. I've also heard Mr. N.K. Devnath, the learned counsel, appearing on behalf of the Panchayat and Rural Development Department, who had produced the records the learned counsel, the standing counsel, though submitted that the petitioner never had an intention of calling for the meeting, convening the meeting. But the fact remains that there is nothing on records to show that the petitioner did not decline to hold the meeting. Upon hearing the learned counsel for the parties and taking into account that the period of 15 days was not complied with as per the mandate of Section 15 of the Assam Panchayat Act 1994, this court is of the opinion that the same amounts to an infraction to Section 15 of the Assam Panchayat Act 1994, and accordingly, on the basis of which the impugned resolution was adopted on 29/5/2023 is bad in law, for which the same is accordingly set aside. This court further, taking into account the order dated 9/11/2023 issued by the Chief Executive Officer of the Nagaon Jilla Parishad, this court have also duly taken note of the office order dated 9/11/2023 issued by the Chief Executive Officer, Nagaon Jilla Parishad, whereby the petition respondent number 8 was asked to exercise the functions of the president subject to the outcome of the present petition. The said order also, therefore, stands set aside and quashed, as the same have been issued during the pendency of the instant writ petition. Be that as it may, this court also cannot be unmindful of the fact that the petitioner now has notice of the petitioner admittedly has the notice of the requisitions so made on requisitions which he had received on 18/3/2023. Therefore, this court grants the liberty to the petitioner grants the liberty to the petitioner to convene the meeting, the special meeting, for discussing the no confidence motion against the petitioner on or before 13th of December 2023. It is made clear that if the further actions shall be dependent upon upon the meeting so held, if conveyed, and if not conveyed, then the law would take its course as per the provisions of the Act of 1994. This court further তাৰ ওপৰত এটা লিখিছো set aside in cost. Set aside in cost and office order of 911 is also set aside liখিছো. In view of the setting aside and quashing the impugned resolution dated 29/5/2023 as well as the office order dated 9/11/2023, the petitioner is restored back to the post of the president of the Rampur Sotra Gaon Panchayat with immediate effect. However, this court, however, makes it clear that the president shall not be entitled during this period to take any financial decision in respect to the Gaon Panchayat, save and except what is required to be done to carry out the day-to-day activities, that too in consultation with you. Who are you? You have any officer?
Over there is the secretary, above that is the,
No, your person is who?
at the district level, we have the CEO, man.
Huh?
CEO.
Consultation with the chief executive officer of the Nagaon Jilla Police.
Highly obliged.
Interim orders, if any, stands
There are none.
no longer survives in view of the disposal of the instrument. So I say
Much obliged. আপনারা